Same only. 22 and 23, 122 and 120, same only. Then 124 and 2. Up to 120. 129. So 124 to 129. Three weeks time is granted to remove the officer. From failing with the matter shall stand automatically dismissed without reference to or order of the court. One 115 to 119. What is that? 10 days. 10 days time is granted to pay the process fee. Failing which the matter shall stand automatically dismissed without reference to or order of the court. So this phrase to be written in 115 to 119 and last. Rest of the only 3 weeks or 4 weeks. Automatically dismissal only in these two categories.
Any mention through VC, sir?
My lord, serial number 11.
Yes.
My lord, due to illness, I could not able to appear today. My lord, kindly I pray for any other date, my lord.
Learned part in person, Mr. Manjunath Arvi appears.
Yes, my lord.
To state that since he is indisposed, you not well, that he could not appear today. Unable to conduct the matter today. He requested for time. Full stop. He prayed for time. Stand over to which date? After vacation, 19th of February, as requested.
Sir, list number 3, seal number 1, the Preeti K.
For the complainant, my lord.
What is the urgency?
My lord, the accused, after interim directions were passed by this honorable court, has approached the trial court and got a new commissioner appointed, my lord. Now there are 2 commissioners acting. That is one aspect of the matter. The other important aspect is
He approached the trial court after order or
after my lord's order.
or order will prevail. There is no need to clarify. There is already an order of the High Court. You can't be, the learned judge was committing improprieties, passing some contrary order.
Same day,
Committing impropriety, passing contrary order to the order of the High Court. So no need to clarify. You take your own recourse. Why should we clarify, which is apparently not correct?
my lord, I accused
Correct,
is not.
correct. Not you, the other side. What is the contempt today?
My lord, my application page number 18 is the order passed. I filed an application yesterday.
IA number?
IA number 1 of 24.
So we'll call for you contempt. Who are you? Come here and face the charges of contempt. What are you doing after High Court's order? You don't have any respect to the High Court order. Who is that? Let him come. This Jain Avanesh, Director of the Code Health Technology Private Limited. Let him be here tomorrow at 11. We'll frame charge and send straight to jail.
Kindly pass it over, ma'am.
No. Why should we pass over this matter? It is kept at 11 o'clock. What are you doing after High Court's order, our order? You're going to trial court and obtaining contrary order?
No.
Yes, who is not, we are not appearing.
My
Then
senior
we
is on the
will
way. Kindly pass it
To
over.
bailable warrant, non-bailable warrant.
No, senior is on the way, my lord. Kindly pass it over.
No, why senior is not here at number 1? Bring your senior, ask your senior to be here immediately.
My lord, the new commissioner
Otherwise,
has
this person
issued.
will straight to go to jail.
No,
If you are committing this improper and deceiving the high court and deceiving the even trial court also by not showing the order of the high court. Come, ask your senior to be here immediately.
Summons are issued to me, my lord, by the new
Okay.
commissioner.
Where is that? You produced it?
This morning, we got the email for appearance today. I will print it. I will keep it ready.
Yes. Ask your senior to be here.
Obliged.
Is seal number 2, to Basuraj.
Delay is 216 days.
Madam?
Delay of 216
My
days.
Yes, Lordship.
My lords,
There is a
we'll
delay.
Submit this, my lords. This is the matter he was just mentioning that we are seeking for the disposal because the writ appeal is not maintainable, my lords, because the learned single judge's order is already given effect to my lords. I shall place this on record, my
No,
lords. A
with the
contempt was filed.
prejudice, as per the contempt order, we have, with prejudice, we had given this order, Lordship. But writ appeal will survive, Lordship.
My lords, it will not survive, my lords. Shall I place this on record, my lords?
Why writ appeal is not maintained?
My lords, your lordship has already dealt in the contempt, my lords. I shall place this on record.
Then there is no urgency. This can be taken up after vacation.
My lords, writ appeal itself is, they can't press the writ appeal, my lords. My lords, your lordship order is at page number 2, my lords. My lords, the operative portion, my lords, is at page number 4. Para 5, my lords, however, the directions of the court cannot be allowed to go uncomplied with. Therefore, it is provided the direction of the learned single judge in order dated so and so shall be complied within 3 months from the date of this.
After vacation, there is no urgency to take.
My lords, it's already given effect to my lords.
No, with
It's already
prejudice-
been given
no, we
posting,
were-
my lords. She's already
Lordship, we
redesignated
were-
as assistant professor, my lords. Writ appeal will not survive for
No,
consideration.
I'll,
Don't think so.
My
Right
lords,
to
at page
proceed.
number 6, they've already complied with the learned single judge's order, my lords.
no, with prejudice, we had given that order, Lordship. Since contempt proceedings, we were
Notice
not
in
the
writ
party.
appeal. Notice returnable on, in delay condonation. Returnable on 18th February.
Please, my lords.
Of which objection shall be complied with next. Failing with the appeal shall stand automatically dismissed for want of, without reference to an order of.
Seal number 3, to Girish Kumar R.
What is it about?
Lord, the matter pertains to postgraduate in-service PG, my lord. The matter was disposed on 19/11/2024, my lord. The order is forthcoming at page 21. And there was a connected matter, my lord. I was a petitioner in WP number 24865. The relevant,
2486.
please, my lord. The petitioner number 1 is, the appellant number 1 is petitioner number 6, and appellant number 2 is petitioner number 5. If my lords could peruse page 60, my lord. After the disposal, there was an order. May I take your lordship to page 60. This order was on in a connected matter, 12/12/2024. All the matters were disposed, and on this day, my lord, we have been aggrieved by the last para, my lord. Further, needless to say that if any seats are remaining vacant and not notified for in-service candidate, the same shall be made available to the second round of counseling for general merit candidates. My lord, this honorable court, my lord, has specifically held, my lord, the division bench of this honorable court has specifically held that you cannot decategorize. I am the petitioner, my lord, that seats should have been made available to us, my lord. May I pause on the judgment, my lord?
No, first explain the controversy. What is the controversy? Thereafter judgment.
Please, my lord, please, my lord.
Unless
The-
we understand controversy.
The
will-
controversy was that, my lord,
What was your petition?
the petition was filed for, there was, there is a reservation for in-service postgraduate candidates. The in-service, my lord, may I explain, my lord? They are the candidates who are working in government hospitals by virtue of their service.
That much knowledge you must attribute to us. What is in service candidate?
My lord, I beg your pardon, my lord. I beg
You
your
must.
pardon. I beg your pardon, my lord.
That much knowledge you must attribute to the court, that what is in service candidate.
Please, my lord. My apologies, my lord. My apologies. My apologies. So this, by virtue of their service, my lord, they are entitled for the postgraduate NEET seats, post-graduation NEET counseling, my lord. And a separate reservation is being earmarked, my lord. Earmarked as per the rules, my lord. And one of the rules that says, my lord, they should have completed their service within 31st of March of that current year, my lord. And that rule is forthcoming at, if my lords could peruse, my lord, rule 10, my lord, which is at page 88, my lord, if my lords could peruse. Rule 10, clause 1, clause A, my lord. I may be permitted to read, my lord. In-service candidate who has completed 5 years of regular employment in service, including successful completion of probationary period, as on the date of 31st March, in which the entrance is held, is eligible to apply for the common entrance test. My lord, what the state has done was that, my lord, this date was extended by virtue of the executive order, my lord, to July 31st. And that was the grievance which was challenged by me in these petitions, that by way of an executive order, you cannot change the rules or amend the rules, my lord. This was my specific argument before the court, my lord. If my lords could peruse annexure F, my lord, which has been produced at page 112, my lord, 112. My lord, last para, my lord, last para of 112. The in-service candidate who has completed 1 year of permanent regular service after the successful completion of probationary period, as on 31st July, in which the entrance test is held, shall be eligible for admission under these rules and is eligible to apply for the common entrance test.
So this
We
is-
were aggrieved by
So this is extension of.
extension.
Beyond-
By a executive order, they extend, my lord. The rule says that 31st March, by executive order, they extend. We were aggrieved by this, and the honorable court stayed the executive order, my lord. But by way of consensus, my lord, where the court said that the government filed a memo, my lord, and that memo is being called out in the judgment. The judgment which has been produced, which is at page 21, my lord, and the memo is at
Paragraph 7.
page 58, my lord. 57, my lord, 57.
Paragraph 7.
Please, my lord.
Paragraph 7.
Paragraph 7, my lord.
What does it?
And it says that, my lord, those who have number of year length of service, if petitioners having more number of years of service, they will be provided the first option. And after that, the other ineligible candidates, they shall be provided with the second option.
What do you say?
My lord, as per the rules, my lord, 31(3) is the cutoff of each year, my lord. Under special circumstances, my lord, twice earlier, it has been extended to 31(7) due to the paucity of number of candidates for paucity of candidates, my lord. My lord, totally 349 seats are reserved for in-service candidates. And each year, my lord, not even half is filled up. Lord, that is the reason why these orders are passed time to time, so that the timeline is extended. So more people qualify and then they may be eligible to take the
What is the business
Counseling.
to you?
Only grievance is that, my lord, the first round of counseling has been completed. After the first round of counseling,
What is prejudice to you?
please, my lord. My lord, I will be eligible in the second round, my lord. The reason is that, my lord, the National Medical Commission or the National Board of Examination, it will be reducing the cutoff of percentile. And once it reduces the cutoff percentile, my eligibility comes in the second round. My grievance is that, my lord, whatever the remaining vacant seats that are there, my lord, let that be retained for the in-service candidates by virtue of the 12/12/2024 order, my lord, that has to be transferred to the general pool. That is my grievance. Let them keep, my lord, in respect of because even last year also, by virtue of the order of the division bench order, they did not decategorize the seats. So in respect of that, my lord, that is the reason, that is my only grievance is that let them keep those seats. And once the second round starts, my lord, I'll be eligible for taking up those seats. This is the only grievance I have.
May I make one submission? My learned friend is saying this on speculation that the percentage
No, my lord.
is going to
No,
be
no.
reduced. There is no express
Please, my lord.
direction from the NMC that they are going to reduce the percentile, my lord. If the percentile is not reduced and we are holding those seats, then those seats will go waste. They will not be taken up by anybody else.
May I pass on one document, my lord?
File your reply.
Please.
You can file, put your stand in.
Please. In fact, my lord,
This one judgment, my lord, division bench judgment,
Consider.
it squarely covers my case, my lord.
but in fact, these two candidates don't satisfy the eligibility criteria.
That is what this, if my lords could peruse 13, para 2 of the judgment, my lord. This was the interim order. In a similar circumstance, my lord, even those petitioners in this case, even they were not eligible at that point of time. If my lords could peruse para 2, the court has passed the following interim, heard the so and so, my lord, has also placed in that para 3, my lord, the interim order. Senior court also placed the supports of submission canvas bearer wherein the material is placed to prima facie demonstrate that respondent number 15 has been adopting the practice of altering the cutoff marks or the qualifying percentile after an initial round of admissions have been completed, and thereby enabling the in-service candidates quota is filled by in-service candidates only. There is some merit in the contention canvassed by the learned senior counsel. In that view of the matter, we direct the respondent number 1 to 4 not to decategorize the seats allotted under the in-service quota, and the respondent number 1 to 4 shall await any instructions from respondent number 15, which with regard to the alteration of cutoff marks. That apart, we reserve liberty to the petitioner to approach the respondent number 15 by way of an appropriate representation. In the event such a representation is made, The same shall be considered in accordance with the established. This interim order was passed, my lord. After passing of this interim order, there was a cutoff percentile that was there, my lord. And with that observation, my lord, the Honorable Court disposed the matter, my lord. That is the reason, my lord, my specific grievance is let them keep the seat for the in-service candidates only. This is my humble submission to your lordship, my lord.
We are not granting an interim.
Lord, immediately after vacations, any date.
Notice written.
But let them not precipitate the matter, my lord, or take any.
Already
Because
counseling is over.
but that
rounds
seats
of
are
counseling
vacant,
is
my
already
lord.
over.
That seats are vacant. Still had 205 seats are there, my lord.
We'll keep it immediately. 8th of.
That's
But by that time, my lord, they would have transferred the seats, my
See
lord.
on that. You have to join the candidates, etc. In the absence of any, all are speculative today. We don't know what.
No, not speculative, my lord. If my lords could see this document, my lord, for the past 5 years, they have been reducing the cutoff percentile. If my lords, please.
in that event, they have not
Yes,
even made
please.
national.
No.
Commission
This,
party meeting.
if my lords could peruse that this one document is sufficient to demonstrate, my lord. This is from last year to 2019, my lord, these documents. If my lords could peruse, my lord, the document number 1 at page 1, they have reduced the cutoff percentile, reduction in the qualifying percentile. And document number 2 pertains to 2022, my lord. Again, they have reduced the cutoff percentile. And this 2023, my lord, they have reduced to 0, my lord. They have reduced to 0, the first document. I'm not arguing on the speculation, my lord, because this is the precedent which they have been following, my lord. That is the reason, my lord, why we got the petitioners in the other matter which I placed before your lordship, they got an interim order, my lord.
Lord, kindly see the dates, my lord.
Till 2019, my lord. 2019, they have been doing it, my lord.
I make one submission, my lord.
Only notice.
I make one submission, my lord.
Please, my lord, let them clarify the stand within 2-3 days, my lord, because the seats will go begging, my lord, in respect of those candidates, my lord. And we had given a consent, my lord, just because
On the contrary, we have found out a good reason to dismiss the petition. Go to paragraph 10 of the order. Still we are receiving notice.
if my lords could peruse the,
After your concurrence, this order is passed.
please, my lord, if my lords could peruse, because this is in the same page 58, my lord, if my lords could peruse the proposal memo that was there, my lord, the candidates upon selection of selected seats shall not,
Respective counsel for the petitioners, after conferring their
please, my lord,
respective clients, submit that they have accepted the proposal.
proposal.
That is how this order is.
We are okay with whatever the things that are, but it is the second round. If my lords could peruse the memo, my lord, that is the reason why we have given the consent, my lord. Page 58, the second para, unnumbered para, my lord. If my lords could peruse that, candidates upon selection of the select shall not reserve liberty to participate in the second round of counseling. All the candidates are requested to possess the such eligibility as may be prescribed or prevalent for the first round. It means it is deemed that, my lord, second round is going to happen. If, my lord, that is the reason, and there is no candidates in respect of the in service, my lord.
Only notice, you file by that. Please, 8th of January before next, 9th of January before next date, the respondent shall file.
Great.
Office of presence will be removed. before the-
Much obliged.
List one, contempt matters. Seal number 1, to Vijay Kumar.
But in this case, I am appealing for
Filed
the,
Our compliance affidavit in this matter. We have filed our compliance affidavit. The order has been complied and further proceedings are, writ petition has been filed and there is a interim order operating against that order which we have complied.
but one submission. But there is a interim order, but in this petition, the division, the petition filed a public litigation. The 1 acre 22 guntas acquired by the one of the builder. But this honorable court, after holding a detailed inquiry, direct the Tahsildar to demolish within 12 weeks. But suppressing the facts before the learned single judge, my lord, the accused filed a writ petition, obtained the stay order. But in stay order, they specifically stated, your lordship kindly see Annexure R2, page 21, produced by the respondent, till the next date of hearing, subject to the order passed by the division bench. My lord, the division bench already disposed of the matter. The matter is not pending before this honorable court. A specific condition is there. My lord, without look into this order, my lord, the respondents are keep quiet not to take any action as on today.
Where is your endorsement?
Lords, proceedings have been conducted. In fact, detailed hearing, my lords, R1. Lords may kindly see. We have passed an order in favor of the complainant saying that there is encroachment and Tahsildar was directed to remove the encroachment. Lords may take page 7 onwards, my lords. And the page 20 is the order, my lords.
This order is stayed.
This order has been stayed, my lords. I produced annexure R2, my lords.
State subject to the result of the division bench of this order.
Which division?
Lordship kindly see page 21, page annexure R2.
You are party in the petition.
No, I'm not part in the proceedings.
Share and become party.
My lord, I filed the impleading application, that matter is application. Your lordship, this is a public litigation. More than 100 crores of rupees, they are encroached the property by the land grabbers. In the interest of the public, the petition filed the writ petition. After hearing 2-3 years, my lord, this honorable court directed the government to take a position immediately. My lord, the officers are colluding with the respondents and the accused person, they are not taken any action. That is the problem. Hello, your lordship, for a moment, my lord, your lordship, with great respect, I am requesting from your lordship, kindly see the R2 produced by the government advocate. But till the next date of hearing, interim was granted, subject to the order passed by the division bench. Where is the division bench order? Already disposed of. My lord, they have to say, what is the division bench order? What is the stay order? Whether, is there any order passed by this honorable court in division bench?
This order vacated if it is not correct.
Let's just continue.
But only saying that contempt may not survive.
My lord, that is not a point here. Lordship kindly see, great respect, I request this honorable court. My lord, there is no any division bench order. My lord, they have to pursue and they have to say on what basis they are keep quiet not to take any action against the land grabbers.
Even if we ignore the R2 order, the endorsement is passed, you challenge it if you are not satisfied.
My lord, that is not a point, your lordship kindly see. My lord, my learned friend produced the annexure R2, the order of the learned singles.
Will not look at R2. Then there is an endorsement is passed pursuant to the directions of a single judge. If you are not satisfied with this endorsement, file an appropriate proceeding.
My lord, there is an order, my lord. Your lordship kindly see for a moment. Annexure R2 produced by the government advocate. See, subject to the order passed by the division bench anta ide. There is no any order. They already
Not looking at R2. Even then, there is an endorsement passed, right or wrong. If it is right, you rest satisfied. It is wrong according to you. Tell
my
us.
lord, they are not complied, my lord. They are not complied.
What is
Just they are produced the order of the learned single judge, stay order. My learned friend produced the stay order passed by the learned single judge in writ petition number 23971 of 2023.
The
But what is it?
The order is in respect of the endorsement, correct?
Endorsement.
So we are not looking at stay order now. We are only looking at endorsement,
Correct, my lord.
which amounts to compliance of the direction.
And it's not like that, my lordship kindly see. This is a public litigation. My lord, they cannot give an endorsement like this.
We
But
will
whether it,
challenge it.
Allah, your lordship kindly see, my lord, this very matter is very serious. More than 100 crores of rupees property is valued in this matter. Just, my lord, your lordship kindly see, there is a specific order by the learned single judge, subject to the order passed by the division bench.
We are not looking at it at all.
But suppose, my lord, if they have produced the order like this, my lord,
Not relevant for us.
Sorry,
far as
Milord.
As far as the contempt jurisdiction is concerned. We are only looking at the endorsement at page 20, operative portion, and we are saying that it amounts to compliance of the direction of learned singles. What else? If you are not satisfied, file a writ petition.
well, there is no any compliance by the government. Just they are produced the order, that's all. If they are complied, let them say.
One thing is certain, Mr. Counsel.
Please.
Either we are not understanding or it is otherwise.
But I leave it to your lordship, my lord, because, and also, according to my learned friend, they are produced some order, the order passed by the learned single judge. But liberty may permitted to implead as one of the respondents in this case.
Sir, we are nobody to give liberty in contempt jurisdiction. You can go there in the writ petition and get yourself impleaded.
My lord, we are already filed the impleading application. That matter is pending for nearly 4 to 6 months.
We are not the panacea of everything. We are in contempt jurisdiction. Will not look beyond the compliance of the direction.
That's correct.
Not an inch away, not an inch.
Allah, see, your lordship, I'm sorry to say, my lord, please kindly see the order. My lord, there is subject to the result of the division bench order. The
We are
specific.
not looking at that.
Allah, my lord, it's not necessary to see this order, but the thing is,
Irrelevant for us as a contempt.
my lord, I agree, my lord, it's relevant, I agree all this point. My submission is, my lord,
So please don't refer that order, don't argue on the basis of that order of learned
my lord, there is no any
We are
division.
not looking at it. We are only looking at it, page 20, which amounts to compliance of the directions of learned single. That's all.
That's correct, my lord, where they are complied, where they are not complied, just they are filed an affidavit.
Read it.
But just they are produced the order passed by the learned single judge. By virtue of this, they are not taken any action against it.
Or wrong, it is not our domain. If it is right endorsement, wrong endorsement, wrongly complied, it is complied with. The directions are complied with. If you are not satisfied on the merits, you can institute independent proceedings. It is all we are saying. Very consistent. Throughout dealing with all contempt.
I leave it to your lordship. I can't
That's
say
correct.
anything.
That's correct.
ಅಲ್ಲ ನಂದು ಏನು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್ ವೆದರ್ ಇಟ್ ಇಸ್ ರೈಟ್ ಆನ್ ದಿ ಲರ್ನರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್
Learned
They-
single,
ಅಲ್ಲ,
we are not-
stay
learned
the
single,
proceedings,
we are not in-
proceedings.
We are not in appeal. We are in contempt jurisdiction.
Contempt, it's true, my lord, I agree, but the thing is, there is a stay by the specific on that stay order, they are complied, they are telling the complied order. Because there is a stay order, we cannot take any action against the respondent. That is the contention in the affidavit and the order. See, there is a stay, I agree, but regarding what proceedings has been stayed, that has to be seen. And also there is a specific, by the learned single, there is a specific interim stay subject to the result of the division bench order. Division bench, already division bench disposed of the matter with direction to take position. The lordship kindly see the last sentence in the interim order. Last sentence, but page 22, sorry, 21, 21 on it. There is a specific order. And my interest is, my lord, to protect the land from the land grabbers in the interest of the state. There is no any personal interest in this case. We have spent lakhs of rupees for this case.
Or learned advocate, Mr. So and so. Complainant and learned additional government advocate. Srimati Pramodini Kishan. Respondent state. The present contempt proceedings originates from order dated 5th September 2022 and the subsequent order passed in conjunction of the said order in a public interest petition. The petitioner therein prayed for direction against the respondent authorities to undertake the spot inspection and survey land bearing survey number 10 at Pattanagare village, Kengeri Hobli, Bengaluru, South Taluka. It was prayed to resume the property, the ground that there was an encroachment, correct, madam?
Please,
Encroachment,
please.
encroachment, full stop. The said petition ended up, the said petition was disposed of. The order dated 5th September 2022, wherein learned single, wherein the division bench of this court issued the following directions. So page 15. 1. 2, 6. Thus, in the above direction, petition was directed to be treated as representation to the Deputy Commissioner Bengaluru Urban, and the state authority was to cause an inquiry in respect to the grievance. And if the encroachments were to be found common, remove them from the public property, giving opportunity to all the, after giving opportunity to all the concerned. It is the aforesaid directions which became, after the said order, from order date 7/8/23 was passed, and further orders, and further consequential orders dated 11/9/23 and 5/10/23 came to be passed by the court, and the okay.
20/10.
Thereafter, after the said order, consequential order can be passed, including order dated 25/10/2023. It is to be noticed that by the time the original directions in order dated 5th September 2022 were acted upon in terms of making inquiry. The Special Deputy Commissioner, Common Capital 2, Bengaluru South Subdivision, Bengaluru. In case RRC, duplicate S, CR-05/2023-24. Undertook the process of conducting the inquiry pursuant to the aforementioned directions, above quoted directions, and passed an order dated 20th October 2023. Course of the operative portion reads as under. Then fourth page. This one. Yes. Page 20. said order and the contents thereof reflect that pursuant to the directions in order dated fifth of whatever I will say, fifth of six. of September. From a detailed inquiry was undertaken and the content owners of the site numbers indicated the operative personnel were directed to vacate and hand over the possession of the land to the government within a week, within stipulated time. The Tehsildar Bengaluru was directed to take necessary steps to remove the encroachment over 1 acre, 22 muthas in the site survey number 10 of Pattanagara village, Kenagari, Hubli, Bengaluru. It appears that pursuant to the said order, as reflected in order dated 25/10 23, passed in the connection with in the conjunction of the original order, the Tehsildar was given appropriate direction to be provided with assistance from law and order maintaining agency, namely the police authority or any other authority, to act upon the direction. Full stop. There is no gainsaying paragraph that order dated 20th October 23, passed by the Special Deputy Commissioner to Bengaluru South, Subdivision Bengaluru, amounts to compliance of the directions of the court as given in order dated 5th September 22, which is the subject matter of the contempt proceedings. As the directions are complied with, and the proceedings of contempt are required to be closed. Full stop. If the petitioner is aggrieved by the said order in any respect and merits, comment would be open for the petitioner to institute appropriate proceedings with regard thereto. In respect of it, this court does not express any opinion on merits. From a learned advocate, learned additional government advocate, invited attention of the court also to the order dated 12/6/24, passed in the petition 2397/2023. Whereby the aforementioned order dated 20th October 2020 has been stayed. Full stop. In the contempt jurisdiction, the court is not concerned with the said order. The proceedings of writ petition before learned single judge shall proceed and culminate in accordance with law. Full stop. From any standpoint, the present contempt petition does not survive and the same is disposed of.
One request. In the writ petition, the lordship is direct to dispose of the matter within 2-3 months. Otherwise, it will take more than 4 to 5 years.
We are
Then
in
the
contempt jurisdiction.
your lordship ಏನಾಗಿದೆ, what happened in that case? We suppressed the facts before the learned single judge after the stay order. So anyway, I filed the impleading application in that case, but the matter is adjourned by time to time. I'm not disputing about that. But the thing is, the matter is pending when there is an order of the division bench of this honorable court. suppress the fact before learned single judge, they are obtained. But anyway, that matter is pending. But if lordship direct the learned single judge to dispose of the matter within 2-3 months, my lord, at least we will get some justice to the party and also to the government, because there are more than 100 crores of rupees. They are the land grabbers. They are very powerful man. They can manage everything in the ACDC office. See, intentionally they are recommend the deputy commissioner. They written 2 orders, one by the deputy, another one. That's why they are filed a writ petition. But if there is a one order, they can't approach the single judge. But anyway, there was some mistake by the officers of the deputy commissioner and the assistant commissioner. Your Lordship, my request is all to direct the single judge to dispose of the matter within 2-3 months at least. Will do something. It's my humble request, that's all.
Seal number 2. So Somchekra RP.
It's, we have served the copy on the complainant yesterday by the mail, my lords. Lordship had directed me to take instructions that there are similar matters disposed of. May I?
That,
I will look into it and I will make my submission. Just now my learned friend has given. I will look into it and I will make a submission. Well, I should kindly out of vacation. Just now I want to go through it and then I make submission. Well, I should kindly out after vacation.
in last week of vacation, only 2 things happened.
Please, madam.
Either the lawyer said that is dire urgency.
No, madam. Now, just now my learned friend has given. I don't know what is written in
Lawyers
the.
come in a covered matter to seek adjournment after vacation
Please.
and wasting the time of the court. Third March.
Seal number 3. Mr. Minto Isaac.
Yes, madam. What is it?
Appearing for the complainant in this case, my lord. But I am before this court seeking the action for KIDB.
Notice
for what?
returnable on. Notice returnable on 11th February.
Much obliged.
Seal number 4, PL matter. The Ramatullah Patwal.
Paper for the petitioner. Lord.
What you are agreed by what? You are agreed by what?
Please, ma'am.
You are agreed by what?
Agreed by the annexure P, my lord.
Annexure
P.
P.
P, my lord. Page 331 of the English translation, my lord. Regarding direction issued regarding the change of khata in the name of WAF, my lord. Regarding the above matter, the wake of the complaint that some farmers and properties khata are being changed in the name of WAF, the Honorable Chief Minister has held a meeting and issued the following instructions. Any office to make mutation in respect of the said matter or direction issued by any authority forthwith, the immediate withdrawal of the mutation process to be suspended. Withdrawal of all notices issued in this regard. No action shall be taken against the farmer cultivating the said lands. As per the instructions of the Honorable Chief Minister, government lettered so and so and Nanapolis have been withdrawn immediately. It's the Supreme Court, my lord. In Syed Ali versus State of Andhra Pradesh. My lord.
So what the circular provide?
Lord, there are out of 1,12,707 and 2 guntas of the land belong to the Waqf board, my lord. There is 91,953
What does
acres
this
of
cir-
land is being encroached by the land grabbers, the mutawallis.
Does this circular provide, which you are challenging in the PIL?
Please,
That the answer we want.
please.
That is the query of the court, specific query, what the circular at annexure P provide, according to you. We don't want any other fact
Lord,
until we understand the real challenge.
Lord, in 2013, there is a government order
Where is that?
number.
Again, you are not answering.
See here, translated copy. NH 294. Page 294, Milord, English translation, Milord. Annexure H, Milord, page 294, Milord. Annexure H 294, Milord.
Annexure
Annexure H, Milord.
290.
Page 294, English translation, Milord. It's a government proceedings, Milord. Proceeding of the state government regarding work properties and the task force formed on the recommendation of the special report in connection with the illegalities in the state work properties and the minorities commission. The special report dated 26/3/2012 submitted by the Karnataka State Minority Commission. In the above special report, the Karnataka State Minorities Commission, as per the basis of the orders of the Honorable Supreme Court, Milord, on Supreme Court in Civil Appeal number 4372 of 1998, dated 28/10, it has been recommended that the task force for the work properties to be formed to get back the work properties. On examining the report, it is observed that in the various districts of the state and work properties have been encroached by unauthorized persons, and having observed that effective action has not been taken to protect these properties and action taken to get back this property, it has been ordered to hereafter implement this recommendation to form the workforce. That is the task force for the work properties in 2 stages, Milord. 2 stages means, Milord, right from the chief secretary, Milord. The additional chief secretary of all the departments were made as the members of the task force, Milord. On the other hand, Milord, the district commissioner, deputy commissioner and assistant commissioner and tahsildar made on the other hand, Milord. So they have to meet on a regular basis within month and 3 months, Milord. They have to report it back to the principal secretary of the minority commission, minority, Milord. So after that, Milord, again 3 circulars were issued by this government, Milord. J. Annexure J, Milord. Annexure J, K and L, Milord. The subsequent circulars issued by the state government. Subsequently, it was directed to the survey the property in view of the amended provisions of section 4 of the Work Act and so, Milord. Page 300, Milord. The first survey was conducted in the year 1962 by the Hindu Religious Endowment Department and Revenue Department. Subsequently, after this circular, Milord, the deputy commissioners of all the district are hereby instructed to issue suitable instructions to concerned tahsildar to survey work properties in the state in accordance with the both provisions of the section 4 surplus 6 of the Work Act 1995. So these are the number of circulars and the notifications issued by the state government, Milord, to remove the encroachments and effect the khata in the name of the work institutions, Milord. The annexure P is in the contravention of all the government orders and circulars, the earlier circulars, Milord. Out of 1,12,000 acres of land, Milord, 91,953 acres of land is been encroached.
Yes, madam, what do you?
My lord, annexure P is an internal correspondence not marked to anybody. My lord, it is not even a certified copy. I don't know how the petitioner has got hold of this communication dated 9/11/2024. My lord, my next submission to my lord is this is politically motivated only to get publicity. My lord, there is in this entire writ petition of 75 pages, there is no cause of action at all. Drafted very leisurely.
Lordship, kindly see the annexure
My
L.
lord, drafted very leisurely with absolutely no cause of action. My lord, this is a very sensitive issue. My lord may see the prayer that is sought for by the petitioner. My lord, there is the Waqf board that is constituted. My lord, if the petitioner had any grievance, my lord, he could have approached the Waqf board and brought it to the notice of the Waqf board, my lord, the grievance that he had. My lord may take the first prayer, prayer A.
Kindly see the
My lord, he
representation.
wants to protect the Waqf properties. My lord may take the prayer.
Lord, we made a representation to the Karnataka State Board of Works twice, my lord. There is no response at all.
Prayer A may
After
be
2
seen, my
months, they
lord.
have filed this, my lord. Will Lordship kindly see annexure L, my lord, wherein the government itself has clarified from the law department, my lord. Your Lordship kindly see annexure L, my lord. Clarification regarding applicability of the Karnataka Religious and Charitable Inam Act, Karnataka Certain Inam Abolition Act, and the Karnataka Land Reforms Act to the work properties notified. Your Lordship kindly see the operative portion, my lord. The opinion given by the Undersecretary Law Department, my lord. Hence, you are directed to initiate immediate action to recover the work properties acquired by the individuals as well as the groups and take legal action against the encroachers who have possession of the work land and the pretext of the above Karnataka Religious Charitable Inam Act, Karnataka Inam Abolition Act, Karnataka Land Reforms Act, and also as per the provisions of the Waqf Act 19, as per the clear-cut legal opinion in this behalf, my lord, given by the law department of the state government, my lord. The Karnataka state government itself has sought legal opinion from the law department, my lord.
The timing of this
Political
public
motives of the
interest
government,
litigation
my lord.
is very insensitive,
During the
my lord.
by-election, my lord, there is a hue and cry. That's why they have withdrawn, my lord. The government's political this man, my lord.
A sensitive issue is taken so casually.
The government should have acted on the directions and the guidelines issued by the Supreme Court in Syed Ali versus Andhra Pradesh, my lord. There is a specific direction in this regard, my lord.
Yes, Mr. Counsel. What do you choose? Are you inviting order? We are
Yes.
not with you.
Lord, our one of the prayer, my lord, to appoint and retired judge of this honorable court, my lord, to oversee the encroachment, my lord.
So you're inviting order, then we'll proceed with you.
Please, my lord.
Inviting order.
We not only challenge the annexure P, my lord, we made a representation to take action to the encroachers we have requested the work board, my lord. There is no action taken by the work board from last 20 years, my lord. In 2006, my lord, Justice Rarendra Sachar committee report says 18,000 encroachment, my lord. Subsequently, when joint parliamentary committee report said, my lord, 19,000, my lord. And subsequently, the state government has appointed one Anwar Manapadi, who is the chairman of the State Minority Commission, my lord. He has submitted a special report to the government stating that there are 54,000 acres of land is being encroached by the these mutawallis and all the land grabbers, my lord. And now in 2024, my lord, board itself submitted before the joint parliamentary committee in 2012, last 2 months back, my lord, stating that there is 91,953 acres of land out of 1,12,000 is being encroached by the mutawallis and all the land grabbers, my lord. This is the data given by the board itself to the JPC, my lord. So we are not only against this annexure P, my lord, the withdrawal of the so and so. So we are seeking to get back the waqf land from the waqf board itself, my lord.
Now you are referring to this earlier order at page 294. Where is that reference in this annexure P?
294, my lord.
It is there, it's referred to in annexure 4.
Yes, my
annexure
lord.
P.
Annexure.
It is dated what? It is dated, no date is given.
Proceedings of Karnataka, annexure H.
In words, 294. You are saying that these are set at naught by the annexure P, but this is not referred to. This has been approved in the meeting of the date and the subject dated 15/3/13. So you are relying on page 294.
294 is the government order passed in the year 2013, my lord, based on the Supreme Court judgment, my lord.
According to you, this should be acted upon.
No, there are subsequent notifications and circulars passed
According
by the
to you?
state government, my lord, in this regard.
According to you, decision at page 294 should be acted upon. That
No,
is your case.
it's in government order, my lord.
That is your case or no?
Please, my
That
lord.
this 294 should be acted upon.
Acted upon.
So is
And they themselves have created a task force, my lord, in this regard. I'm not insisting on the interim order, my lord. I'm just insisting on let them file their objections.
No,
Why they have
I
taken
oppose, my
U-turn?
lord.
Why they have U-turn?
No,
When there is
no.
a government order, they are based on the Supreme Court judgment, my lord.
Nothing. This is filed only to create a political turmoil, my lord.
And even annexure L to be acted upon.
What is this? Just to understand. At page 332, despite the order of Chief Minister, Sanyanya, what is that?
Sanmanya, my lord, Sanmanya. Sanmanya, Chief Minister.
Sanyanya, that is what?
Honorable, my lord.
Honorable, my lord. Honorable Chief Minister.
Acha, honorable.
Ah. The annexure L to be acted upon, my lord.
Yes. This writ petition number 33213 of 2024.
We make a last submission.
Pardon?
The petitioner is a retired case officer, my lord. So he has petitioner, my lord.
Who is retired?
Retired officer, my lord. Karnataka State Administrative Service Officer, my lord. So he has been requested by some institutions to present the case before the Joint Parliamentary Committee report, my lord. So after coming to know that there is 91,953 acres of land is been encroached in the state, my lord. He made a representation to the work board, my lord, to recover the same, acting on all the circulars and all. There is no response from last 2 months, my lord. So after that, we filed this writ petition. There is no political, as the government advocate has mentioned, my lord.
We are not saying any political thing
Please,
in the,
please.
any matter. We are on the merits. So you need not answer all allegations. Heard learned advocate, Mr. Rahmatullah Kotwal. You are Rahmatullah Kotwal.
Please, my lord.
For the petitioner and learned additional government advocate, Srimati Nilofer Akbar, who appeared on behalf of the state of Karnataka and its authority, upon service of copy of the petition in advance. His writ petition, styled as public interest litigation, is filed by the petitioner who claims to be a social worker, who claims to be, as per averment in paragraph 2 of the petition, to be the social worker and resource person of Hajj Committee of India. It is claimed that the petitioner works for upliftment of the poor and the needy, especially the poor and the needy, especially for minority communities. In course of the submission, learned advocate for the petitioner stated that the petitioner is also a retired government servant in the Karnataka, having served in the Karnataka Administrative Service. The grievance and challenge put forward by the petitioner in this petition is in respect of circular dated 9/11/24 into bracket figuring at page 3, copy figuring at page 331 to TO2, 332, annexure P on the record of the petition, bracket over, which is issued by Additional Secretary to Government Revenue Department and to bracket land grant, land reform and land revenue, bracket over. Addressed by the Principal Secretary to the government, to all regional commissioners and district collectors. It is regarding change of khata in the name of Wakaf. It is stated that in view of the complaints received from some farmers, certain farmers, that farmers and other khata holders of the property, private khata holders of properties, that their khata is being changed in the name of Wakaf, comma, the Honorable Chief Minister, upon convening a meeting, issued direction that such mutation processes shall remain suspended, and that any directions issued by any authority in that regard shall forthwith stand withdrawn. It is also stated that the instructions are passed to withdraw all the notices issued in that regard, and to provide further that no actions will be taken against any of the farmers or farmers cultivating the land or the private khata holders. Earlier instructions on the subject, if any, are directed to be withdrawn. Learned additional government advocate would submit at the outset that the aforesaid circular is only an internal communication, and it is not comprehensible as to how the petitioner could manage to obtain the copy thereof to make it the basis for this petition. Be as it that may. Be as it that may. Learned advocate for the petitioner, while praying to set aside the aforesaid circular dated, aforementioned circular dated 9/11/24, proceeded to emphasize and rely on certain proceedings dated 10/5/13. Certain proceedings of the government which resulted into order dated, which had resulted into order dated 10/5/2013. Therein, it was deliberated inter alia that the workforce for Wakaf properties at the district level,
That is task force.
should be formed to identify all the properties. And also, and whether such Wakaf properties have gone out of the hands of other people. To undertake the task force was expected to undertake the survey work. As per the Wakaf Act from 1997. To identify the boundaries of the properties which are claimed by the Wakaf. And to fence such properties. It was provided to get khatas of the Wakaf properties in rural and town areas as per the Wakaf notifications, Wakaf deeds, etc., to ensure that the Wakaf khata is created in respect of various properties. it was stated that the workup force in the state, at the state level shall meet every 3 months and should take measures as ever. Highlighting the said contemplations from a learned advocate for the petitioner would submitted that there is no good reason as to why the said measures should not be acted upon. Paragraph. With such basic challenge and grievance in the premised in the petition, the petitioner wants to withdraw the aforementioned circular dated 9/11/24 to brand it, by branding it arbitrary exercise of powers, and the contents of the circular to be illegal and untenable. The grievance is also about alleged mismanagement, not alleged, encroachments, acquisitions, and exploitation of the alleged mismanagement, encroachment, acquisitions, and exploitation of the work-up properties by individuals and government of Karnataka, which, according to the petitioner, have been highlighted in the multiple reports, including the report of the Joint Parliamentary Committee. It is stated that it is claimed that the encroachments or the work of property should be removed, and the state government shall have to take and state government is expected to take necessary steps. In the perception of the petitioner, the work of properties need to be protected. Else it would lead to significant losses. And would become impediment in the upliftment of the socio-economic progress of the community. Unless the work of properties are better managed and preserved. Full stop. For all the aforesaid purposes, the aforementioned prayer for withdrawal of circular dated 9/11/24 is advanced. The prayer for withdrawal of the said circular dated 9/11/24 is advanced. Full stop. Along with the said main plank of the prayer, the petitioner has put forward spate of other prayers. First is to permit this petition to be agitated as public interest petition to protect the properties of the Waqf in the belonging to the Karnataka State Board of AUQAF, AKAP, Bengaluru. The second prayer is to set aside the aforesaid circular dated 9/11/24. The third prayer is to consider the representation of the petitioner in the above regard. The fourth prayer is for directing the respondents to conduct a judicial inquiry into the encroachment. One second. Fourth prayer, paragraph. Judicial inquiry into the encroachment of Waqf properties in the state. It is also prayed to ensure fair reimbursement of the properties acquired under the Land Acquisition Act or by way of allocating alternative land. And also to recover physically all the Waqf properties. It is the further prayer to continue the process of entering the names of the Waqf to be continued in revenue records. The seventh prayer is to direct the Chief Secretary of the state to compliance the provisions of Section 104 capital A of the Waqf Act 1995. Paragraph. Petitioner wants to prevent the politicization of the Waqf properties, Waqf matters in the print, electronic and social media. The next prayer is to treat any statement, actions or contraventions in relation to the subject matter to be deemed as a contempt of the court. The ninth prayer is to identify the encroachment over the Waqf properties. It is also the prayer to take action to restore the Waqf properties to Waqf institutions. The prayer is made to direct the authorities to identify the Waqf properties given on lease and to ensure that the lease are given in accordance with the Waqf properties lease rules 2014. When learned, paragraph, additional government advocate submitted that the present petition is politically motivated, that it is publicity oriented, that though it is leisurely drafted, it lacks substance for the reason that it is too vague to be countenanced. And further, that the bona fides of the petitioner is to be doubted for the reason that he has brought under challenge an internal governmental communication by somehow and anyhow obtaining copy thereof from our all worth to be countenanced and could not be brushed aside lightly. Full stop. In addition to the above aspects, comma, the petition makes variety of prayers highlighted above. All the prayers are the subjects to be dealt with in the executive realm by the executive authorities. Full stop. Though the petition is drafted with lengthy readings, comma, they are in the nature of general statements. Full stop. The paragraph. The statute called Waqf Act 1995 and the rules made thereunder in relation to the administration, management and protection and administration and management of the Waqf properties and for agitating any issues regarding any issues in that respect. those act and the rules have to be adverted to. Full stop. The directions to deal with the workup properties in particular manner or otherwise would not become a subject matter of public interest litigation when the field is occupied by a law in the nature of Workup Act. The provisions thereof, if to be applied, could be utilized in accordance with law by the petitioners, if permissible, in respect of individual cases, for which the petitioner may have grievance. Full stop. An omnibus public interest petition, like one, could hardly be tenable and can only stand meritless. If the direction is issued by the authorities to stop the creation of khatas in the name of workups in respect of the properties or lands which are cultivated by farmers or which otherwise belong to the private khata holders, such direction could be pursued only in the public good and public interest. Full stop. This court cannot go into such aspects, but they have to be adverted to individual cases to be dealt with in accordance with law. Full stop. For all the aforesaid reasons, the present public interest petition is thoroughly misconceived and meritless. As public meritless, it is dismissed with cost of ₹10,000 to be paid to the Karnataka State Legal Services Authority within 15 days, and the receipt thereof shall be produced on record of the petition by submitting it to the registry.
On submission
Obliged,
of-
my lord.
Kindly waive the cost, my lord. It is purely in the interest of the public. He has filed, my lord. Kindly waive the cost, my lord. My humble request.
At this stage, learned advocate for the petitioner submits that the cost part may be dispensed with. It is dispensed with.
Obliged.
Obliged.
This is number 5. It's a PIL, Mr. Srinivas Murthy, yes, sir.
Survey number 10/5 of Gudlumudi and Haldi village has been sanctioned for construction of the primary health center in the year 1999 itself, Mila. From thereafter, there were so many communications by the authorities to the concerned persons to evict the unauthorized persons staying there and to complete the hospital there for the sake of public convenience, Mila. In this regard, there are correspondences have been made from the year 2020 onwards, and no action has been initiated. We have
Who are
given
you?
Mela?
Who are you?
I'm a aged person living there. I am an aged person representing the villagers to have the
Villagers.
hospital for the general public. And there is no personal interest for the petitioner because if the hospital comes there, there are so many villagers have the benefit of the hospital facilities in rural area.
So you are against construction of hospital? Health center,
Ah,
No.
complete the health center.
He's in favor.
Favor. So very good.
At the age of 70, he is fighting out for the sake of common cause. Let the hospital come there, it will be utilized by the common public.
They are not constructing the health center, they are not constructing.
They have requested the authorities to evict the persons for staying unlawfully there. Despite giving the directions by the government to the authorities, they did not act it. They would have taken the police assistance and to evict them to construct the hospital at the earliest possible. The representation has been given even for about 6 months back. Till now, they have not initiated any action. My lord.
Illegal occupants who have entered. Hakkupatras. Even the Lokayuk has also drawn attention. So Lokayuk is dealing with the matter.
Lokaयुक्त has also instructed to initiate the appropriate action to evict them and to go with the construction. The authorities given deaf ear for that also. And in fact, what they are claiming they have obtained Hakpatas has been cancelled by the authorities.
So who has entered illegally according to you?
I have mentioned the names. My lord. They are not.
Why they have entered? You want them to be evicted, but they are not party.
They are not parties. They have gone far before the authorities also. The suit has been dismissed. But the authority has said that Tahsildar has stated that they have not. They have cancelled the authority.
Similar like previous petition. Similar treatment like previous petition, but a mild treatment. What do you want? Again, we asked like you asked in the earlier petition. You want to withdraw or you inviting order?
Because this man will get satisfaction of having approached the court some month. He can.
Our learned advocate, Mr. So-and-so for the petition, and learned additional government advocate, Srimati Nilofar Akhtar, who appeared to assist the court after service of the copy of the petition in advance.
Let them consider my representations at least.
You want to withdraw and consider representation?
No. Let them consider my application.
That will direct. But you withdraw for that purpose. Otherwise, some observation will come in your way.
I leave it to your lordship's consideration.
No, I will leave it to you, sir.
No.
The grievance of the petitioner, who is an agriculturist and a villager, which is styled as public interest petition, is that though the authorities have sanctioned at particular place construction of primary health center for the villages Gudulu, Gudde, Nahalli. For the village Nahalli, area of 5 men. Vijayapura Hobli, Devanahalli Taluka, Bangalore Rural District, in survey number 10, in the land survey number 105, the authorities have failed to construct the same to the benefit of the general public. It is the allegation that it is 103 or 105?
105. 105.
It is the allegation that in survey number 103, certain persons whose names are mentioned in paragraph 6 have.
It's survey number 105, not 103, 105.
But you have said that the health center in 105, but that person have entered in 103.
It's 105 only. Yeah? This is the type of that.
Have entered the said land illegally, and thus the construction of primary health center is not permitted. The petitioner has the grievance about the lethargy and inactiveness on part of the authorities in not evicting the illegal occupants as alleged illegal occupants, and in not proceeding expeditiously with the construction of the hospital oblique primary health shelter. It is the case that though the construction of primary health center was approved as back as on 4/1/2020, it is not being constructed for the aforesaid reason. The allegations about the encroachment by some private persons over the land earmarked by primary health center and the veracity thereof raises disputed questions of fact, which cannot be gone into by this court. It is for the respondent authorities to look into the said aspect after undertaking necessary inquiry and take consequential legal action as may be necessary. Full stop. While the construction of primary health center, if approved by the authorities, as approved by the authorities, is undoubtedly a project of public purpose, when the representation of the petitioner is pending in this regard, the court expects that the authorities shall look into the said representation and take an appropriate decision without booking any delay. The authorities may also take necessary legal action after examining the allegations made by the petitioner about encroachment of the said. Without expressing any opinion on merits, the present public interest petition is disposed of in the aforesaid.
Cell number 6. Sumo to PA.
I appear behalf of amicus curiae, my lord. The state has filed the reply, my lord.
My colleague is there.
Documents of.
Oh,
Lords,
no.
I'm
This
here.
matter is all- Which is this matter? What is it?
Lords, this is regarding that the backward classes, the SC/ST hostels, my lord.
After
There were
vacation,
three
After vacation,
after vacation. I'll file my written submission.
12th March. That ST hostel.
Yes, my
Yes,
lord.
yes,
My
my lord.
lord found that there were some deficiencies which we have cured.
My lords, there are three directions that was passed, my lord, on the one of the dates, my lords, which is on 20th of
File.
August 20. I'll file my written reply.
My lord,
You file report reflecting latest position on the next one.
my lord, on the last date of hearing, my lord had pointed out certain deficiencies. My lord, those deficiencies I have cured and I have filed these 710 pages, my lord.
Very well.
My lords, I have received the report. In that, there were three directions, my lords. Some observations were made, and finally, there were three directions passed, my lords, regarding the details that need to be furnished. Insofar as second and third, there is some explanation given in this latest compilation affidavit. But no timelines have been given so far as the first directions to fill up the vacant posts of senior warden and junior warden is concerned.
After vacation.
I'll file my written.
Cell number 7. Nayana Tara BG.
My lords, the learned amicus had some difficulty and just had to step away. It may be passed over, my lords. The learned amicus had to just step away, some difficulty.
After vacation. After vacation.
There's no urgency.
Certainly, my lords.
No urgency.
Oh,
No
no.
urgency. Please, my lords.
Which is the matter that
The child custody, my lords.
The guidelines for child
Child.
custody.
it is no doubt important subject, but not that urgent.
My lord, a lot of non-custodial parents will be affected, my lord.
11th March.
My lord, that's too long a date, my lord.
Very
The non-custodial parents will be affected, my lords, without the guidelines. So March would be too long a date, my lord.
27th February.
Much obliged, my lords.
But- January, my lord. January, my lord.
Sir, deeply grateful, my lords.
My pleading points,
I will hear you. I will hear you whole day on that.
I couldn't get it. What is it?
He'll hear that.
On
Green bench matters, seal number 8. Sir Ravindra Gajanan Kolle.
Please, my lords.
कौन सी matter है? Please. Fill number. Last question. नहीं, last one. Now, 8 is also PIL.
No, my lord, this is a mine's matter, man. So I am petitioner is the first applicant, my lords, in respect of the queries area. Filed in the year 2011, which was kept pending till 2023 amendment came into force. By the time, 3 more applicants have filed their applications subsequently, which was also not considered. And in the interim, petitioner filed a representation on June 2024, produced annexure J, my lords, which was not considered even to this day. Annexure J at page number 69, my lords. And without considering that representation, an order came to be passed by the 4th respondent senior geologist, which is produced at Annexure A. My only limited prayer is, my representation may kindly be considered and passed suitable appropriate orders thereon, my lords. That's the limited prayer I am making before my lords. I am getting a priority in terms of erstwhile Rule 23 of KMMC rules, which existed earlier to 12/8/2016, that when my priority is there, when I have filed an application.
Here is showing notice.
May-
Notice returnable on 15th February.
But
Obliged.
in the meantime, direction may be issued not to dispose of the other applications, my lords, so that my right will be forfeited.
Which application?
Because other 3 applicants that respondent number 5, 6, 7, they had also filed their applications.
My lord, notice, my lord has ordered notices to them. They'll have to come and, my lord, urge their
No,
contention
they are
before my
private
lord.
respondent.
Respondents 5, 6 and 7.
Yes, they are private respondent.
Correct, correct.
So now 3rd and 4th respondents might pass some orders. Thereby my rights will be either frustrated or taken away. Only some directions or some observations, my lords.
Heard learned advocate. Mrs.
My lord, I don't know the status of their applications, my lord. In case if it is considered, my lord, then there'll be,
So far it has not been considered, my lord.
no, I wouldn't know that.
No, by going through the documents which I have produced with
Government
latest.
Srimati Neelofar Akbar upon service of copy of the petition in advance. So what is this order 22, 21, 21, 10, 24?
Yes, my lord.
Let us.
Hmm?
No, this is not on the ground of seniority of the applicant. It is
No,
on the-
I have got first priority.
My lord, but the mineral is different, my lord. That's the problem.
that mineral is different and mineral which I have applied is different.
Yes.
Then the order dated 21/10/24 passed by respondent number 4. Deputy Director and competent authority, Department of Mines and Geology, whereby the application of the petitioner for quarry lease for area at quarry lease number 29 of 2011. Quarry lease, stone quarry lease is not extended, is not accepted on the ground that the area applied overlaps the quarry area of other.
True, my lords.
Full stop. The assertion of the petitioner is that the petitioner has applied for grant of co-release in the area of 6 acres in survey number 4 at Humalapura village, Chikkaballapura Taluka, Chikkaballapura on 22, as back as on 22/9/11. And that the private respondents number 5, 6 and 7 have applied subsequently after 6 months. In other words, the claim of the petitioner is that his application is prior in point of time, and in any case, it deserves to be considered in that context before the application of the other subsequent applicants could be considered by the authorities. Notice returnable on 19th February.
Please, my
Say
lords.
13th February.
Please, my lords.
The area, the respondents include respondent authorities shall maintain status quo
Please,
with regard to the area applied by the petitioner.
please, my lords. But in the meantime, notice may kindly be issued by the learned government advocate. my lord.
Learned
Hey.
government.
I'm receiving.
In addition to this, in addition to normal mode of service, my copy, you are already given copy.
Yes, my lord.
That's
Before
the-
filing, we have served, but
No,
again, I will. be-
Take a notice, I'm here immediately, the communication goes, my lord.
I will comply, my lords.
So writ appeal matters, seal number 9. So Manjunath BS.
Delay of
I-
139.
I'm for the respondent, my lord. They need to
Only-
serve the copies, my lord. They have not yet
Only-
to serve
only
the copies.
You are the only respondent?
Yes.
Only respondent.
No. 7.
No, you are not the only respondent. Mr. Several respondents. So notice will have to go in delay. Notice returnable on 11th.
Copies has to be served on me.
I'll serve it.
Much.
Serve the copy today. Notice written on 12th of February.
Much.
Seal number 10. Srimati Sandhya, you Prabhu.
Appellant was a petitioner before the trial, single judgment. And he's a borrower, my lord, who had availed the loan of, housing loan of 22 lakhs, my lord. Thereafter, my lord, once he had challenged the sale before the debt recovery tribunal, my lord, where he was put on a condition to make some deposit, my lord, which is duly complied, and the amount, my lord, outstanding amount had come down drastically to 17 lakhs. From that 22 lakhs, my lord, to 17 lakhs 82,000, my lord. Thereafter, my lord, say,
What is the total amount payable to the bank,
totally 22 lakh 50,000 was my lord, it was a initial demand.
So-
Thereafter,
Then,
17 lakhs 82,000, my lord, it got reduced by virtue of the payment which he had made when, before the debt recovery tribunal, my lord. Then again, my lord, they had proposed for sale of the property, which was challenged before this honorable court, my lord, before,
it is a residential house.
please, my lord.
You are for bank.
Respondent bank.
Auction has taken place.
Auction is taken place, sale is confirmed, my lord.
Sale is also confirmed.
Confirmed, yes.
That sale
Possession
is
is
now
fine.
challenged.
Sales certificate is
Possession is
registered.
not taken, my lord. Presently, I'm in the possession, my lord. And that order, my lord, of, for
But-
taking possession has been challenged before the debt recovery tribunal. SC is pending, my lord. The
Then-
sale subsequent to the sale notice, my lord, sale certificate, issuance of sale certificate, my lord, I have challenged it before the debt recovery tribunal. Only in so far as, my lord, when this sale notice challenge, my lord, sale notice, my lord, sale certificate is a continuation process of sale notice, my lord. When the sale notice was challenged before this honorable court, my lord, partly the conditional order, interim order dated 31/5/23, my lord, for deposit of 5.5 lakhs, my lord. He paid 1 lakh. Thereafter, my lord, he met with an accident. It was a major accident. He was bedridden. He couldn't communicate me also. When the matter came for final disposal, my lord, I was zero with the instruction, my lord. I didn't even have any instruction, my lord, because client was not communicating with me. His mobile was switched off. That was brought to the notice of the court also. But because when during the final disposal, my lord, I made a statement that my client, as per my knowledge, the client has paid only 1 lakh. The counsel, my lord, for the respondent, my lord, he submitted that it is 1,10,000, my lord. But wherein later to that, my lord,
Sale notice part is infectious because auction is held.
Yes.
please, my lord.
Now the confirmation is challenged before the debt recovery tribunal
Sale certificate is challenged before the debt
Sale-
recovery. Please, my lord.
by you.
I have challenged.
So any amount you are ready to deposit.
My lord, one submission, my lord. Interim order was passed on 31/5/2023, directing the petitioner in the writ petition
In this
before the
writ
civil
proceedings.
judge to
In
make
this-
the payment
in
of
this writ process.
Please, please.
Yes.
5,50,000 rupees within 6 weeks.
He says he met with the accident.
3 extensions were given to the petitioner to make the payment. 3 extensions by the honorable single judge. Despite the extension given, the petitioner didn't pay the interim, comply the interim order. 3 extensions. Only part payment was made.
A day before the disposal, my lord, 2 lakhs was paid, which I was ignorant, my lord. Bank was knowing, but the council made a submission that it is only 1,10,000.
1 lakh subsequent, 1 lakh.
Had that would have been brought to the notice of the
No.
court, my lord, that
No.
3 lakhs has been paid. Probably I would have got some favorable order. I
No.
was not, my lord, client did
3
not contact me. Later to that, my lord, I
Not
wrote up
3
a
lakhs,
letter
only
and I
2
called him. to
Only
my
2
office.
lakhs 10,000 was paid in 2 installments. 1 lakh 10,000 in the initial stages. Subsequently, 1 lakh was paid after the second extension.
It was a day before the disposal.
Where is that interim order of the IA?
1/5/23. Yes,
Is there with you?
they have.
I got a Xerox copy, my lord.
Pass it. No, not that. About deposit of the amount in IA.
Next page, my lord.
Next page, conditions.
This 5,50,000
5 lakhs 50,000.
is what? Total
Now,
Total
30% of the outstanding amount.
30% of.
Please.
30% outstanding in 3 installments within 6 weeks.
You have paid how much?
2 lakhs.
2 lakhs. Now ready to pay what amount?
My lord, the 3 lakh, my lord, I am ready to, if I'm given with 1 month time, my lord, I'm ready to pay the entire outstanding, my lord, whatever is the due. Parallelly, I'm ready to pay
Entire
the
outstanding amount of the loan.
total due.
Loan.
Full, my lord.
Then very thick, you can,
Because sale is confirmed already. Sale is
that will work out there, but we are protecting here, that's all. You work out, if you are agreeable, yes, non-agreeable, work out there. Your rights and remedies in the debt recovery tribunal.
Tribunal.
Where the sale certificate is. sent.
Certificate is issued.
We record that he is ready to.
Yeah.
The residential house, why should we give? When he is ready to. What is the total amount outstanding? 22 lakhs.
22 lakhs, my lord, now it's reduced to 17 lakh.
Out of
82,500.
22 lakhs, 5 lakhs they have paid already. Of course, but the only thing is the sale certificate
Out of 1782, my lord, after payment of 2 lakhs, my lord, it is 15 lakhs 82,000.
The appellant original petitioner is aggrieved by order dated 14th December 2023 of a single judge in writ petition number dismissing the writ petition number 1114523. Full stop. Therefore, the present appeal. In the background, comma, the facts are that the petitioner had obtained loan from the respondent Karur Vaishya Bank Limited to the extent of rupees 22,50,000 for the purpose of building residential house. Full stop. As the petitioner committed default in the repayment, the proceedings were initiated by the bank to recover the loan under the Surface Act. Under the Surface Act, Pura name, Surface Act. The case of the petitioner was that it was due to the COVID-19 spread of COVID-19 pandemic and the lockdown of the affairs in the society resulted at that time, the petitioner was unable to pay up the dues of the loan. It appears that paragraph, the action taken by the bank resulted into conducting of auction pursuant to sale notice dated 11/5/23, published in the newspaper. Sale was conducted and the sale certificate came to be issued. Petition was filed by the petitioner challenging the said sale notice dated 11/5/23. And further to direct the respondent bank to regularize the loan account of the petitioner. The first part of the prayer against the sale notice dated 11/5/23 has become infructuous since the auction is already held, be as it that it may. In the proceedings of the said writ petition paragraph, the court issued notice, the learned single judge issued notice on 31st May 2023. On the same day, while dealing with interim application number 1 of 2023, following order was passed by learned single judge. Here. Pura, yeah. A subsequent order dated 20th/7/23, learned single judge granted further 3 weeks time to make the payment of installments as contemplated, as permitted in order dated 31/5/23, further observing that if the amount is not paid within the extended time, the petitioner will run the risk of rejection of his petition. Finally, paragraph, the petition came to be dismissed as per the order impugned in the present appeal on the ground that the petitioner did not pay up the amount of installment as per order dated 31/5/2023 and within the within the time extended as above. Paragraph. In course of the hearing today, learned advocate Ms. So and so for the appellant petition submitted that the appellant has already challenged the sale certificate before the debt recovery tribunal
In essay number 99 of 24.
by filing essay number 99 of 19.
And also in the writ petition, simultaneously they have filed a writ petition.
2024. He said proceedings are pending. Full stop. The only it was further submitted that the petitioner is appellant petitioner is ready to discharge the entire amount of loan due to be payable to the bank, which is approximately 17 lakhs.
16 lakhs.
16
After
lakhs.
17 lakhs, 2 lakhs was paid.
After adjusting the
That
amount which is
subject to
already
the
paid.
calculation of the interest, subject to this interest now.
With
Let them
interest.
cal-
With interest.
With
Shall we
interest.
record the commitment?
My lord, presently I will show my bona fides by making the principal, my lord. Interest, let them calculate it.
Ready to discharge the entire outstanding amount of loan. Full stop. Paid aspect may be worked out in the proceedings of the original application, which is pending before the debt recovery tribunal. Full stop. For the purpose of proceeding of this appeal, comma, it was stated by learned advocate for the petitioner upon instruction by the appellant upon the instruction of the appellant that the appellant is ready to deposit what amount today?
15 lakhs. That's
10 lakhs.
17 lakhs,
Today itself,
not today, a month,
today,
a month,
17 lakhs.
please.
Not, my lord, 17 lakhs is the book balance. Now subsequent for the intervening period of interest we are charging.
Towards the outstanding.
Yeah.
We'll say towards the outstanding,
Yes.
towards the outstanding.
Yeah.
Within 1 week.
1
Full
month,
stop.
1 month, madam.
1 month, sorry. It is provided that it is directed that out of the said 17 lakhs, amount of rupees 2,50,000 shall be paid to the bank and of liquor deposited with the debt recovery tribunal that the proceedings of original application pending within 2 weeks from today.
My lord,
We are protecting you.
Please.
That for 2.5 lakh you pay out
please,
of 7.
please, please,
To
please.
today. Full stop.
Out of that,
Condition that.
my lord, out of the amount, my lord. May, I
Out
would
of-
like to ask for the,
Out of.
out of that,
No,
please,
naturally,
please, please.
Out of which 2.5 lakhs will be paid, public deposited with the, paid to the bank, public deposited with the debt recovery tribunal in the original proceeding, in the original application proceeding, within 2 weeks from today. Full stop. On condition that the appellant petition pays public deposits the aforesaid amount of 2.50 lakhs, comma, the bank shall not take any further coercive action against the petitioner. Full stop. The proceedings of OA number 9924 shall proceed to be decided expeditiously by the debt recovery tribunal in which the parties shall cooperate. Full stop. The readiness on part of the appellant, loaning, to clear up the dues of the loan and the submission on behalf of the bank made by learned agreement so and so, that the outstanding amount would include the interest also, shall be worked out before the debt recovery tribunal, keeping in view the reasons advanced by the appellant for his inability to pay the loan account in view of the COVID-19 period. Although this court does not express any opinion on the merits of the case.
Greatly,
The appeal is disposed of
my lord,
accordingly by setting aside the impugned judgment and order of law assembly.
please. My lord, may I make one submission. That amount depositing, my lord, I'll make it to the respondent only, the bank only.
The only bank will pay through the bank.
I'll pay to the bank because if I pay to the debt recovery tribunal, it goes to the Ministry of Finance, my lord.
Okay. Now don't trade deposit with the debt recovery.
Please, greatly.
The 11 adjourned. Cell number 12, Mr. Bhargav ji.
Lordships, there is a delay of 7 days.
Notice returnable on 11th February.
Cell number 13.
97
Ma'am,
days,
I-
man.
Same notice return 13th February.
Please.
14 adjourned. Cell number 15. Mr.
Same
Srikanth
notice
MP.
return 15 notice return on 17th February.
Cell number 16. Mr. SB Mukanappa.
Appeal for petition, appellant, my lord, kindly have done after vacation.
After vacation.
Yes.
10 over to 19th February as requested by learned advocate for the appellant.
19th.
My lord.
Cell number 17.
No, delay of 32 days.
My lord, in this case,
this appellant challenged the judgment of the learned single judge. He met with an accident, met with an accident. Appellant met with an accident. He's a driver come conductor. He met with an accident having 55 to 56 disability. So he was given alternative job. Then he was asked to undergo another test manual. Because the earlier certificate which is produced here goes to show permanent disability, sir. There is no possibility of recovery. But anyhow, the second certificate shows that he had no disability. Therefore, he was directed to attend the driving work. He was directed to. But since he has no strength in both the lower limbs, so the commissioner, respond number 4, Commissioner for Disabilities, directed another medical test by the Director of Medical Education, Medical Board, Koppal. The board examined him and gave an opinion that he has got 56% of disability. So he can't drive a vehicle, public vehicle. So he may be given this light work. That is the third certificate. Then the KSRTC the challenge that order of the Commissioner for Disabilities before this learned single judge. This certificate, third certificate, was not brought to the notice of the learned single judge. Therefore, the report of the respond number 4 directing to give light job instead of driving has been set aside now. And on the basis of the judgment of the learned single judge, he has been directed to attend the driving work.
But there is a delay of
one minute. Now he could not attend the driving work. Then now they have ordered there was issued charge sheet to take departmental inquiry, disciplinary action, because you did not join the duty. Therefore, I have produced that charge sheet also, copy of charge sheet yesterday itself I have produced it. Therefore, there is a delay of 32 days. So pending consideration of that,
it can. Once, unless delay is come, notice returnable on 12th February.
Then by hand, the notices may be ordered by hand.
Hand delivery is permitted.
Hand delivery, sir.
Service by hand delivery is.
Please.
18, 19 are urgent. Still number 20, state appeal.
Delay,
My lords.
15 days.
Lords, this may be listed immediately after vacation, my lords. The validity of the section is challenged. Learned Advocate General would be appearing in this matter. my lord.
All right, early will give. 17th January,
15 January notice.
17th. 21 also delay.
21,
Appearing for the matter may kindly be taken up after vacation.
Notice returnable on 25th January, February.
still number 22,
Appear for the
is
appellant.
Jose Anthony.
But the appellants are the writ petition is, my lords, the writ petition is dismissed. My lord, the issue in this is that the issue is in this is that I am an institution who had availed the service of third respondent security service provider. And the EPF, my lord, the first and second respondent has found that the
What time you got the remedy?
my lords,
Under section 7I of the Act.
my lord, the issue is that under rule 7(2) of the EPF rule in the tribunal rules, there is a limitation, my lord, that is 60 plus 60 days. Even at the time of the filing of the writ petition itself, it was lapsed. But ineffectively, there is no remedy available. My lord, the maintainability and intertainability of the writ petition is on different footing. But the matter is,
We have whiled away time and in the meantime, the limitation goes, it can't be held.
my lord, though,
By backdoor, you can file a petition and get the limitation condon.
my lords, sorry.
You can't get the limitation condon by backdoor by filing a writ petition.
My lord, the issue is squarely covered by the Honorable Supreme Court order, my lord. Only because of some technical issues, my lord, if I am, it is not entertained on merits, my lords, I will be.
Heard learned advocate, so and so, the writ petition
But only one more submission, my lords.
of the petitioner came to be dismissed. by order dated 28 October 24 by learned single judge, which is the order impugned in this appeal. Full stop. The challenge in the writ petition was to order dated 25/1/23, passed by the Employees Fund, Employees Provident Fund Organization. Full stop. Several grounds, learned single judge observed that the order which is challenged is passed under section 7A of the Act, against which an appeal lies under section 7I, capital I, of the Employees Provident Fund Miscellaneous Provisions Act 1952. The writ petition is dismissed on the ground of non-availability of the order and administrative remedy of filing the appeal under the aforesaid section 7I of the Act. Full stop. No error could be booked in the approach of learned single judge when the alternative statute remedy is available, the court would not exercise the.
At the time of filing the petition, there was no adjudication.
Not exercise the extraordinary jurisdiction. The appeal is meritless and is dismissed.
But at the time of filing the petition, there was no presiding officer.
We are not here to condone the delay in the petition.
Grateful minutes.
Number 23 to JN.
Appellants. My lord, appellant 2 is a nursing college which is run by a charitable institution.
Same.
My lord, may I just pass along the order sheet, my lord, if I may, because the issue as to the maintainability vis-a-vis alternate remedy was adjudicated by the learned single judge's predecessor. My lord, I kindly see this order sheet. Let's pass this. Kindly see the last page. My lord.
What is this?
My lord, this is the order in the writ petition. The order sheet, kindly see the last page, my lords. The second last paragraph. It says, though it is pointed out by the learned counsel for the respondent that the order is appealable, taking note of the order at Annexure K, the matter could be entertained. So an argument is urged by the respondent, my lord, that there is an alternate remedy of appeal and that I have to exhaust it. But this matter was argued and Annexure K was pointed out to demonstrate that the respondent, my lord, which is the BESCOM, has passed contrary orders in other matters pertaining to my properties itself. But in this case, they are not doing it. So in order to demonstrate this Annexure K was produced. The learned single judge notices this.
I'll review before learned single judge, pointing out this interim observation and the treatment given to the other similar petition. That is what you are saying.
This observation is not even documented in the impugned order, which is challenged before my lord.
So therefore you file a review. We are not entertaining. This is interim order for which there is no value of interim order. We will look into only final order. If you are saying that some past development was there in the nature of this
That was
observation.
not considered when passing the final order. That aspect was
Correct.
not
We
considered.
understand your argument, but then you go before learned single judge, seek a review, point out that this was the observation at the interim stage.
Till such time, my lord, at least by the time I go, let the BESCOM not take any precipitative action, my lords.
You go file immediately.
But this point was urged even at
We'll
this stage.
record this, that this was observed by learned single judge. Nothing more than that.
Yes, my lords. But in fact, this was brought out to the notice of the learned single judge. I would understand, my lord, if this aspect was considered and
And we are not
distinguished.
entertaining the appeal with the question of granting any interim observation.
Grateful.
So we are drawing.
Withdraw with liberty to file
Learned, the order which is impugned in the writ petition dismisses the petition filed by the appellant petitioner on the ground that the petitioner had remedy under section 127 of the Electricity Act 2003 of filing in appeal against the order which was sought to be agitated and impugned before learned single judge. Full stop. Learned advocate pointed out that in the interim order passed during the proceedings of the petition, from observations were made by learned single judge that the petition could be entertained, be as it may. Full stop. In course of the submissions, today learned advocate Mr. So-and-so seeks permission to withdraw the present appeal in order to move learned single judge with appropriate application, including the review application, as prayed for by learned advocate for the appellant. Full stop. Permission is granted. The appeal stands with appeal is permitted to be withdrawn as above. However, this court does not express any opinion on the recourse which may be taken by the appellant.
This number 24, state appeal.
Lords, this is the state appeal, my lords. We are aggrieved by the order of the learned single judge.
Delay of 307, yes, delay again,
We have
307.
filed explaining the delay, my lords. Contempt petition is pending, my lords.
Anybody appears?
Lords, there is a caveat, but they are not here, my lords.
Notice
May I just
returnable.
point out one important aspect, my lords, before this honorable court. Since the contempt petition is pending, I may be permitted to make submissions on the matter. Lords, in this petition, my lords, the respondent number 1 was dismissed in 2005. The appellate tribunal confirms it.
You can say to the contempt court that now writ appeal is pending.
Your Lordship may kindly tag along the contempt petition. Contempt petition number 997 of
We are
2020.
not observing. Whenever it comes before any bench, you can submit that now my writ appeal is afloat.
Your Lordship may kindly issue notice at least.
A notice we are issuing, notice returnable on, in delay condonation application, returnable on 20th February. Next.
Pledge.
Number 25. The XM Joseph.
Please, my lords. Lordship will kindly see page number 9 of the paper.
Page number
9.
9.
The issue that falls for determination, Lord says, whether an interim order dated 27/9/24, which is not an ex parte ad in interim order, but an interim order passed after hearing both the parties to the list, could suo moto unilaterally be vacated without pleadings of the respondent or respondent's application vacating interim order. Second, my lords, is not the impugned order dated 8/11/24. The suo moto unilaterally vacates an interim order dated so and so. Contrary to law laid down by the 5-judge constitution based on the Supreme Court and High Court Bar Association, Allahabad versus the state of Uttar Pradesh. Your Lordship will kindly see para 45 of the constitution based judgment. Para 45 minutes. Your Lordship will kindly see the order sheet, which I produced at page 21.
What was the order dated 27/9/24?
27/9, your Lordship will get it. Page 23, my lords, after hearing the respondent sought time. Therefore, it was directed to be listed for consideration interim period of 27/19/2024. Now,
Very
it was
good.
listed on the appointed day at page 26.
7/9.
26. Page 26 is the
7/9.
impugned order.
Where is 27/9/24? Here it is. Parties are directed to maintain status in their possession and the title of the scheduled property.
This was after hearing the
Why,
part.
why it was vacated?
Pardon, lords.
Why it was vacated?
My lords, there is no pleading. No application is filed for vacating interim order. An oral statement is made that sale certificate has been issued. That sale certificate, my lords, on this point, my lords, if your Lordship will kindly see page 199. I file an application for recalling this order.
19?
199 is the application which I filed for recalling this order vacating the interim order, which has been granted after hearing the parties. Now at page 201, para 4.
No, we understand that it is passed without hearing you. But on what ground? The sale was conducted.
That's on a oral statement made by the learned counsel for the.
Thing must be there on record.
It is not there, no pleadings. That is also not recorded. The submission is also not recorded.
But what is your instruction?
Your Lordship will kindly see, my lords, your
What are
Lordship is
your
aware of
factual-
it.
What are your factual instructions? Sale has taken place? You must be knowing about.
Sale date, sale, my lords, para 4 at page 201. Sale certificate is issued on 19/10/24.
Page?
Page 201. It's on this ground, my lords, because it's a contempt. The order was dated 27th of September 2024,
Sage certificate issued on,
19/10/24,
where is that?
para 4.
There are 4.
The interim order directing to maintain status quo as to possession and title was on 27/9/2024. Whereas there 3 weeks later, that's on 19/10/2024, the response in demonstration of contempt, showing disrespect to the order of this honorable court, defied this order with changing the title of the petition scheduled property by registering the sale certificate.
So sale took place after this 27/9.
Yes, please, my lords. Yes, sale had taken place on 27/9/2029.
Shown to learn a single judge and he is vacated.
Now, without there being any pleadings, without there being any application vacating stay,
No,
and
this
it
is
is
a
contrary
fact.
to
You are-
para 20
you are
45,
admitting
the 5-judge constitution bench judgment. Your lordship will kindly see.
You filed this IA when?
Subsequently, I filed, my lords, I filed it on. Immediately, I filed it, my lords. I filed it on 13/11/24. I filed it on 13/11/24. You can understand if it is an ex parte ad interim order. It's an interim order after hearing the parties.
– 19/10/24 is date of court.
19/10/24, they go and register the sale certificate.
Registration.
Register the sale certificate.
Sale took place when?
Sale took place on the 14th of September.
14th of September.
So I'm sorry, sale took place on. Your lordship gets that page. At page 134, your lordship gets the sale notice, auction sale notice at 134. At page 134. On 13/8/24, my lords, sale is took place on, I'm sorry, 12/8/24, sale takes place on 12/8/84. Your lordship gets it here. And your lordship will see the description of the property there. Page 134, right side, property, how it is described is only 2 lines. No schedule, nothing. Your lordship gets it here, my lords. Only 2-line notice.
No.
Page
that is
134.
the sale notice, but sale took place when? That's the.
12/8, my lords. Your lordship gets
12/8,
it at
14/8.
12/8, 12/8/24.
No, 14/8/24, not 12/8.
Your lordship gets it at
12/8.
fourth line of the notice.
But then therefore it is much before page 26 order.
Yes.
Much before 27/9/24 order.
Yes, my lords, but sale certificate had not been issued. Because the party has to deposit the money, then only the sale will take place, sale certificate will be issued. On that day, when the interim order was passed, it was a submission that sale certificate has not been issued. which is why the other single judge said maintain status as to possession and title.
Who appears? First time it is coming. Fresh time. We should notice.
Yes, Vignesh Shetty appears in the matter. Mr. Vignesh Shetty.
Notice. Notice. At this stage only notice.
Let there be a stay of that order, my lords, because they'll change, my lords, what happens, my lords, is if I'm dispossessed, that order, impugned order is virtually an approval of whatever bank has done.
Better option is to go before learned single judge and get it disposed of expeditiously.
My lordship will see the description of the property, only 2 lines. No schedule, nothing.
All that you want notice or you are going to go back to learned single judge. We'll relegate you without interfering in the order. But asking learned single judge,
And
requesting.
in fact, my lords, under section 26 of B, 26D of the Surface Act, only if it is registered with the central registry, they could exercise the right of securitization. Your lordship will kindly see section 26D.
Not necessary to be seen in this process.
So I am not submitting, my lords, I am going only on the impugned order.
Notice. You want notice or?
Let
you
there
want-
be a status quo as to my possession at least. Otherwise, if they dispossess me, they'll create third-party interests. Let there be an order as to status quo as to possession as on today.
You can try to bring the learned advocate who appears for the other side, who appeared in the writ proceedings.
Well, with due respect to
Tomorrow
the
we can-
respondent bank, my lords, they are indulging in all kinds of unfair practices. Your lordship is aware that last February, it is the very same bank who asked the dead person to come and collect the documents.
If somebody appears today, tomorrow, even today, then we can pass some order directing status quo as on date and requiring learned single judge disposal. That can be done.
Your lordship may have it next week, my lords. I'll serve the copy on Vignesh Shetty.
Next week,
I'm sorry, tomorrow, on Friday, my lords.
Friday, no. Thursday we can. do. Tomorrow we can.
Yeah, please. my lords.
Thursday.
Yes.
Okay, take chance. If somebody appears, give the copy.
Please,
If
ma'am.
possible, yes, without any commitment.
Yes.
Without any commitment to pass any order, we are keeping it on.
Obliged.
My lord, serial number 41, my lord, after vacation. Serial
All
number-
vacation you can seek. Wherever the learned advocates seek after vacation, they will be granted.
ಅಲ್ಲ ಗುರುಗಳೇ, ಹೌದು. ಅಲ್ಲ, ನಾನು ಅದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೇನಲ್ಲ, ಎದಲ್ಲಿ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಇದು ಮಾಡಿದ್ದೇನೆ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಸರ್ಪ್ರೈಸ್. Last week I moved the memo for early hearing. My lord, this court already granted time, my lord, 7/1, my lord. Due to the medical ground, I have sought for memo, my lord, for early hearing. Day before yesterday, the matter listed, my lord. They are not posting the matter. They are not posting the matter, my lord. The pending, my lord. Pending, my lord. Your lordship given a date, my lord, day after tomorrow, my lord. They are not posting. I requested the court officer to sought for mentioning that.
So you're mentioning or complaining?
I am not complaining, my lord. Due to the medical ground, I already moved the.
We are very serious about it. Are you mentioning or complaining?
Mentioning, my lord.
Mention, then in the better way to mention, not to complain. Yes, what is the mentioning?
Mentioning, my lord, the matter may be reponed, my lord.
Why? File IA. File IA. It can't be postponed once the date is given.
May I make
Yes.
one submission?
Yes.
Item 26, my lord.
26, yes.
May be called on 9/1, my lord. In the amendment, my lord can dispose the appeal on 9/1.
But there is a delay of 36 days.
Even condoning delay also, my lord, 6 months is the time for suspension. My lord. It will be ended on 9/1, my lord.
So you
Who
want to,
says 9/1 automatically, they will be deemed to be in reinstated.
only the 9/1?
9/1.
Stand out to 9/1. 25, as requested by Leonard Advocate for the appellant.
Right.
Yes. How many matters? 230. 231. That's all. Then we.
Crossover matter, list 3, seal number 1.
For the accused in this case, my lord, I would like to file two memos to explain. An observation was made in the morning that we have not mentioned to the court below of the order. I have given this screenshot that we have mentioned it.
No,
One.
No, the.
No, that was
submission
not
is
the
that,
submission.
So one nimsha, I like to bring a couple something notice to them.
DG.
My lord, in this application that they have filed, one of the allegations is we have sought for another commissioner. And we are not giving the website with the source code. And third one is we are not activating secure socket layer on the website. And third, we are not activating the website. So I'll start with, I've given a screenshot. In this, it says, heard both sides, advocate for defendant is me, filed a memo and produced order passed by Honorable High Court of Karnataka in contempt petition so-and-so, and filed a memo to appoint fresh court commissioner. Honorable High Court of Karnataka in contempt petition directed the defendant to comply the directions on or before 6/1/2025.
You have filed IA, madam? You have filed some IA?
I have.
IA,
I have filed an IA, my lord.
where is it IA? IA number?
IA number 1 of 24, my lord.
It doesn't have an accompanying affidavit.
It does, my lord.
A copy of that has not been served upon us.
So which are the proceedings of before the trial court? This
7123 of 2020.
7-1
7123 of 2021, my lord.
OS.
OS. And in that some application is filed.
No, no.
That
My
for
lord,
We had
appointment-
filed a memo for appointment of a new commissioner.
Commissioner, memo.
This honorable court passed interim directions on 25/11, my
For
lord.
appointment, that is produced by you.
I produce it.
I
I
have
produce myself. I've given that. I produce this myself.
my application, my lord. Page number 13 of my application.
Duties by filed by you.
By me.
So this commissioner is so to be appointed for what purpose?
For two purposes. One, I filed this application. I claim that several copies of my source code are in the server that is right now belonging to the plaintiff. That has to be looked into. My I number 13 is a matter of record which has been filed. At page 98 of the petition filed by the complainant. At page 98.
Where did the order pass by the trial court?
The recent order, my lord, page number 18, my lord, of my IUA.
The original order is at page 106.
No, order on memo.
Order on page number.
That is the one.
Same.
That is
Page
the
number
one.
18.
What is the auction?
I'm sorry, my lord. My lords may please refer to the memo filed by the other side. It appears like there's a wrong document that is produced.
What wrong document has been produced?
No, by me,
By
me.
you.
It appears like
So you are wrongly produced.
I've order of some other case I must have produced.
Order is wrongly produced.
I have produced the right order.
Instead of, the accused has produced the right order.
You have to produce this order. Where is that order in your memo, in your IA?
My lord, in my IA, that was the order I actually sought to produce. This is the order.
We want from your record. If we copy you gave, we'll take on record, even by.
My lord, I'm filing another memo to produce documents in which one of the
Order
email
which
has
is-
the order.
Order which is passed by the trial court upon memo submitted by him, by the other side. We want to come from your side. Where is that? It may be the same order with this one. So we'll substitute this order by in place of page 18. नहीं, order चाहिए.
My lord, in this last page number, my lord, page number 8.
It. So you don't have the formal copy of the order. This is for what? This is in what?
On
This
the
is
courts.
From
The
the
e-courts
court's
website.
website, my lord.
Website. So you don't have.
We
the
were not
copy.
anticipating that application will be filed like this, my lord. We are trying to comply with the order, but there, my lord, one submission, my lord. The reason I filed this application is my second document I filed. In the IA that they have filed, they claim that their commissioner appointed is not available until 23rd. In this email that was sent, he says, Siddharth Patsarthi is their commissioner. I received documents from the court yesterday. Unfortunately, I'm traveling from 23rd to
Playing
21st.
smart with his court or that?
No, my lord, I'm not trying to, no, my lord, just 1 second. The commissioner is unavailable, my lord.
Playing smart with this.
No, my
court or
lord.
That court.
No, my lord. The commissioner is unavailable. Please have a look at the email sent by the commissioner.
Certainly not tolerate, Mr. Counsel.
My lord, I'm my
Playing
sincere
smart with the
apologies.
court will not tolerate.
My
And
lord,
we are going to be coming
My lord,
very heavy
my lord,
with
my sincere,
yourself and the judge who has passed the order.
my
Who's
lord,
this judge who has passed the order in overreaching the High Court?
my lord, there is no overreaching of High Court, my lord.
It is overreaching, Mr.
My
Counsel.
apologies, my lord, may I make a submission, my lord, just 2 minutes. My sincere apologies, I would like to make a submission.
It's very unfortunate.
My lord, I understand, my lord. My lord, there are 2 aspects to the,
The trial judge is trying to overcome the High Court order.
no, my lord,
At
that is
the
not the
instance of
intention.
the
That is
litigant?
not the intention, my lord.
Who is this judge?
My lord, kindly have a look at my second document that I filed today. The commissioner is unavailable.
He is overreaching by all means.
My lord, I'll withdraw my application tomorrow. The
And
matter is
you are instrumental in it.
No, my lord, I am not. My lord, kindly have a look at this. I am bound by this honorable court's direction to comply with the order on or before 6th of January. That is, my lord, I'm doing everything. My lord, kindly have a look at this document that I have filed. An email sent by Siddharth Patsarthi. My lord, kindly, I'm requesting you to have a look at page number 2. My sincere request.
It's really annoying.
My sincere apologies, my lord. All I can offer is, my lord, if the commissioner is unavailable until 31st of December, my lord, kindly have a look at my,
After the order was
my lord,
passed.
kindly have a look at,
Not before
my lord,
the
1 second, my lord.
order.
We have looked at everything.
My lord, my lord,
We have looked at, we have
my lord,
looked
this is the
beyond
document
the,
I filed today.
beyond the scene, we have looked at, we have
My lord,
read, we have read
My lord.
between the lines.
my lord, I am making a submission which we have recorded right now. I am going to make a submission before the court and I am going to get the commissioner that we have appointed to be removed tomorrow consistently.
No.
My lord, beyond that, I can only offer my apologies, my
So
lord.
beyond what we want to do, can't do.
No, my
It's
lord,
not-
that is not, my lord, kindly have a look at page 2.
And what we want to do, we'll do it.
My lord, yes, my lord, kindly have a look at page 2. Page
Will
2.
not see anything.
My lord, if the commissioner is unavailable,
Contempt on the face of it by the litigant and also by the court.
my lord,
Contempt of the High Court on the face of it
my lord,
by the litigant and the court
I
concerned.
offer my unconditional apologies for this.
So look at the order passed by the trial court.
I would like to say a couple of things, my lord, in my defense.
The trial court imposing the court commissioner over the court commissioner appointed by the court.
There are, no,
This-
my lord, this commissioner,
This-
my lord, this court and its order did not appoint a court commissioner.
We don't need any explanation. The explanation is
My lord, 1 minute,
available
my lord, my lord, my humble
from the
submission.
record itself.
My
Yeah.
lord, my humble submission, my humble submission. I am offering my unconditional apologies
No,
before this honorable court.
we are not going to accept.
My lord, if the commissioner is unavailable to perform his duties until 31st of December,
No repentation after committing murder.
my lord, my lord,
Anybody repents after committing
No, no,
murder,
my
what's the
lord.
use of it?
we are not trying to commit any murder against anything, my
Really
lord.
annoying.
My lord, I understand, my lord. I'm sorry, I'm offering my unconditional apology here. My lord, this honorable court,
In the proceedings of
my
contempt
lord,
petition.
my lord, 1 minute, my submissions, just record my submission for 2 minutes, just my submission for 2 minutes. My lord, I have been given date till 6th of January 2025 to comply with the order.
We don't want to hear any argument.
No, not argument, my lord, it's my pleading, my request, my prayer before your lordships. This court has given a direct direction to me to comply with the order on 6/1/2025. I am willing to comply. The only bone of contention is whether to hand over the source code or not. My lord, right now, since we are at fault, because we filed something else, I am willing to transfer the source code as well. Kindly record it. We are willing to, whenever they say, we'll do it, my lord. It's like completely giving up our case, my lord. My sincere apologies. We will be willing to transfer it with the source code. Yeah, of course, my lord. My lord,
Out of question.
my lord, my humble submission. My lord, the court commissioner who was appointed is unavailable 23rd of, the 31st of December. I have to comply with the order by 6th of January. How can I do it, my lord, if he's not available? My lord, I have no intentions,
But
either
the memo-
my or my clients.
Commissioner was filed much before the earlier commissioner informed of his.
My lord, that is because at page number 127, an interim report has been filed where he is opined that source code is required. My lord, kindly look at my second page, third page should I have filed. He says it's an opinion. My lord, basically we are letting go of our rights in the source code because a contempt petition has been filed. My lord, I take complete responsibility and ownership. I am offering my sincere apologies. We are not trying to my apologies that it has been deemed like I'm trying to play smart on this court or that court. I'm not doing it.
Which is the court which has passed this order?
CCH10.
CH10.
CCH10.
Pardon?
CCH10, portal number, CCH10 in City Civil Court.
What is the designation?
I think it's
Additional
district judge kind of.
District judge.
My lord, my lord.
Third additional city civil judge.
Please.
Court all number, CCH10 is,
It's very unfortunate.
my lord, my humble submission, my lord. I'm offering my apologies. My lord, kindly listen to me for 2 minutes, my lord.
Not
I'm
taking
begging you to listen to me. My lord, on 6/1/2025, I have to,
Taking any action in your
no, my lord, not like that, my lord.
change 10. But still we will not leave the matter.
My lord, my humble, my lord, okay. My lord, I cannot impose even my most minimalistic arguments on this honorable court, my lord.
What
My
do you
humble
want?
submission, my lord, my humble submission is, if I am not able to comply with the order on 6/1/2025, when the commission not available is 31st, how is it going to, no, I don't want to come and cut a sorry face before your lordships again on 6/1.
Yes, we have taken note of it. We have taken note of it.
My lord, I'm offering my unconditional, most sincere, I'll give an affidavit saying this, I'm sorry.
Taken note of it, sir. We have taken note of it.
My lord, just because of, I genuinely,
Kindly listen to the order now. We have taken note of it. So you want to comply with our order?
yes, my lord.
That's right.
My lord, but my humble submission is, in this court, when the order was passed, your lordships clearly stated source code is a matter of trial.
In the proceedings of contempt petition number.
We are willing to offer it, is what I'm saying.
Kindly listen now. Order.
My lord, I'm worried, my lord. I'm
Don't worry.
worried that this honorable court thinks that I've done, I'm trying to play. Play smart on this honorable court, which is not true.
We are not the court which will cross the limits.
My
Like
apologies.
others.
My apologies.
Yes. Contempt petition number 423 of 24. The present contempt proceedings which are pending before this court. Witnessed an interim order dated 25/11/24. In the said order, after detailing the controversy and the rival case in relation to the contempt alleged, certain directions came to be issued by the court. Paragraph. The directions as recorded as given in paragraph 18 of the order, 3 days and then quote paragraph 18. Pura. 1, 2, 3, 4, 5. 19. 9 up to paragraph 19. In the order, it was recorded in paragraph 11, inter-alia, that the learned advocate for the respondents had submitted that the respondents were willing to provide and extend cooperation to fullest extent to the court commissioner to implement the directions. This court in the aforesaid directions, above quoted directions. The court directed the court commissioner who was already appointed by the court below to carry out the directions upon furnishing the details and to activate the website. 4 weeks' time was granted to comply with the direction. Instead of compliance, the proceedings, the present proceedings. Instead of not influence the compliance. While the compliance was awaited from the respondents, interim application number 1 of 2024 came to be filed by the complainant. It was stated that although this court had issued interim directions on 25/11/24, asking the court commissioner to proceed as per the various directions issued, subsequently the respondent approached the trial court. Respondent accused approached the trial court for appointment of new commissioner. It was stated that accused refused to host website with source code and refused to activate the website on his server. The contempt was alleged by the complainant in the contempt petition on the said very score, SCOI. It was further stated that as per the directions, the complainant provided details to activate the website on 2/12/2014 through.
My lord, it was not provided to us. Nothing was provided to us.
My lord, we offered to purchase the SSL and provide him.
Forget it, forget it.
It was not provided to us.
It is stated that when the complainant requested the respondents to comply with the direction, an email dated 4/12/24 was issued by the respondent raising certain aspects and thereby did not comply with the directions. It is further stated that on the very next day, that is on 5 THATIS, 5/12/24, the respondent accused filed a memo before the court below for appointment of a new commissioner. Full stop. The memo was filed despite the clear directions given by the court in the aforesaid order dated
25/11.
25/11. We don't want anything.
My apologies. Sincere apologies.
We
Apologies,
don't
my
want
lord.
any kind
Sincere
of
apologies. I'll not open my mouth. Apologies.
No assistance by of interrupt.
Apologies.
We are in full command of the fact.
Apologies, my lord.
And
Sincere
the
apologies.
first thing I don't want myself is the interpretation when the order is dictated
Apologies.
by any side.
It won't happen again.
Yes. Because it breaks the chain of the thinking. Yes, what did you write? (25/11/2023), 4. Interestingly, paragraph. Even as the order dated 25/11/24 was operative, awaiting to be complied with, the trial court accepted the memo. Full stop. Not only that, the trial court proceeded to pass order dated 5/12/24. Proceeded to pass order on 5/12/24. The order is not available so far, except on the website of the court. Copy of the said order was produced by learned advocate, Ms. So-and-so for the complainant, which was also produced by learned advocate, Ms. So-and-so for the respondent. The order reads as under, and this is the order to court. Noticeably, the court did observe, the trial court did observe in the said aforesaid order about the pendency of the contempt petition before this High Court, and noted that the High Court of Karnataka in contempt petition directed the defendant to comply with the directions on or before 6/1/25. Notwithstanding such knowledge with the trial court, the aforesaid order came to be passed. Full stop. It is highly unfortunate and deprecable that although this court had passed the aforesaid order dated 25/11/24 and had issued clear directions, comma, the compliance thereof was interjected by the respondent. The respondent filed a memo to seek appointment of another commissioner. It was nothing but an attempt to overreach the High Court's order. Admittedly, the directions of the order passed by this court were not complied with within the time stipulated. Full stop. The order passed by the trial court on 5/12/24 runs counter to and in conflict with, comma, to say the least, for the conduct of trial court in passing such order, comma, the order passed by this court on 25/11/24. This court takes a very serious view of the matter. Full stop. It is directed that all proceedings before the which court? (53rd) 58 additional city seal says Bengaluru. In OS original suit number 7123 of 2021, pursuant to the filing of aforementioned memo dated 5/12/2024 by the respondent herein shall remain stayed. Full stop. At this stage, since learned advocate, Mr. So-and-so, learned of the respondents, submits on behalf of the respondent unconditional apology and further assures the court that the respondent will comply with the directions of this court in order dated 25/11/24, comma, the court desists, this court desists from issuing any further direction, taking a lenient view. Full stop. Stand over to 7th of January.
May I make a submission? Lord, the commissioner is not available 31st of December. We are willing to transfer as and when the commissioner comes. But if at all the commissioner, for whatever reasons, is not available between 1st and 7th, that may also be noted.
Don't know ifs and buts.
My lord, I'm giving information that.
No
you know,
ifs
these
and
days-
buts. We want compliance of the direction.
My lord, we are willing to comply.
Do it.
Everything we will do,
Do it.
but under the supervision of the commissioner.
Otherwise, your client and the judge,
No, my lord.
both would have been docked.
My apologies. my lord. I'm just saying, we are willing to do it, but commissioner should be available. That's all I'm saying.
My lord,
We are equally soft but equally strong.
Apologies, my lord. Sincere apologies.
And the contempt of the court and overreaching of the court's order will not be tolerated at any cost.
My lord, my sincere apologies.
my
So
lord,
do
Intention was
whatever
not to play smart on the court, but only to enable.
Now, therefore, this is a
Complaint.
chance given to you.
Thank you. my lord. Much
Seventh,
obliged.
seventh.
Much obliged.
So what is your grievance? Commissioner may not come.
Yes, my
Then you bring both of you, the commissioner.
My lord.
You request the commissioner to come
lord.
in.
He is unavailable till 31st because in the,
Commissioner said he will be available from the 1st, my lord.
Where? Who is the commissioner?
Uh,
Sridhar
once the-
Pathsarathy.
Some advocate?
No, not advocate, but he's a technical
technical
expert.
person.
expert that plaintiff produced.
So we are not passing any direction. Only recording your assurance of compliance
Yes.
and putting up the matter on 7th.
My lords, again, they will come on 7 telling source code
No,
is
my
not
lord, we are
part of
giving
the
it.
order.
I'm giving it, I've made a submission. It has been noted.
What date is given?
Source
Let us-
code is not noted.
If it is date is given, let it be same date.
9/1.
Please, 9th, my lord.
9/1,
Ninth.
not 9/1.
My lord, it's the
The,
18th.
the contempt proceedings shall be listed on the date already
Yes.
fixed.
My lord, 18th edition. The court below, it's not 58th.
18th. Learned 18th.
But before I leave, once again, my apologies. Intention was not to, my lord, I
Don't you,
don't know what to say, my lord. I'm feeling so bad.
don't you think that apology is accepted?
I know, my lord, but still, inside, I'm feeling bad that, it has been found that.
Doesn't, now forget it, we are all professionals,
Yes.
nothing to be,
Yes,
becomes,
but my lord, as an advocate, if.
nothing to become sentimental, all our professionals.
My lord, it is.
We are court of law, not.
No,
you.
my lord, I keep my profession at the very highest ethics, but this is something
So
very
forget
bad.
about it.
Apologies. Much obliged.
Always welcome.
Much obliged. Thank you so much.
I had filed a Xerox of the affidavit, my lord. I'll file the original affidavit in the counter for my IA because the power of attorney.
And you also see that it is complete, it is you cooperate in compliance.
Please, my lord, please,
No harassment to other side.
please.
No
Please, my lord,
harassment to other side.
absolutely not.
Much obliged.
Because this is a highly technical matter, we don't know unless you, both of you cooperate and comply with, it will not be complied.
Oblige me.
You also need to supply the
Definitely.
instrument and information details.
We have already purchased the SSL, my lord. That
My
has
lord,
to be-
SSL certificate again. Oh. They have to give access to their server, my lord, that's all we're asking.
You settle the whole,
We are, my email says so, my lord. Much obliged.
thank you very much. It's next.
List one, seal number 140
Yes.
for withdrawal of appeal.
Appearing for the appellant, my lord. This is for withdrawal. The underlying writ petition has been dismissed as withdrawn. The writ
Figures on
appeal is now
record of-
infructuous, my lord.
Figures on the record of the record of the appeal, memo dated 13th December 24, which reads as under, quote the memo, in view of the above memo dismissed as withdrawn.
Much obliged.
Memo to be quoted.
Seal number 142. Hanumanth Reddy Ji.
Appearing for the appearance. Lord, I have to file, I'm for the respondent 1, 2, 3. I have filed objections to this idea for stay. I have yet to receive the affidavit from the parties. Kindly have it up to 1 week or during January. Lord, there's.
What is the contempt? What is the urgency?
Lord, there is an apprehension of the execution from the other side, my lord, because there has been
Are you
enhancement to a
Are you
larger
executing?
extent.
Are you executing?
I will file my objections
Have
on
you
this,
filed execution proceeding?
that I am not They aware haven't of. filed as of yet, my lord.
They have not filed, then where they go?
They
Come if
haven't-
they
Not-
execute.
Please, please, please. my lord.
11th of February,
First,
1st January,
first or second week of January.
23rd January.
Please, please, obliged.
Seal number 143. To Shankari Gowda.
Number 2 in this case.
Appearing for appellant, my lord.
What is it?
For R1.
In the last occasion, let's, number 1, the builder. Notice was like ordered to be served. Notice is awaited.
After which date?
Second week of next month, Lord.
10 week of
Next month, January.
January. 17th January.
Obliged.
Seal number 144. To Saravana S.
Please, Minos, appearing on behalf of the home buyers, Minos.
Not in this case. Was previously at senior counsel. Sam Sundar appeared, Minos. Today, some personal reasons is not in the town. He has requested for tomorrow, Minos. Only 1 day accommodation.
Milots, they have.
What is the urgency?
I have filed my application, my lord, in termination of proceedings today, my lord. We put up tomorrow. My lord. I also see.
Milots, there are execution orders to the tune of 150. No one is either implementing the execution orders, nor is there any solution for it.
My lords, for a second.
Any urgency?
My lords, on 1/4/2024,
Can wait.
they file affidavit, my lords. They pay the partial payment, they show the bona fide intention. And kindly peruse the affidavit, my lords. It is all there on page number 6. They have given a tabular column wherein they say when they are gonna pay. They have already made partial payment. I don't understand why they don't want to pay. They have convinced this court that they are gonna make subsequent payment, and that has been recorded. And now they want to take up a different issue altogether in contravention to their own affidavit, my lords. The state is not filing any compliance reports. This contempt proceedings is going on from past 1 year. The executions are stalled.
My lords,
Compliance.
Accused number 4 and 5. My lords, out of 750 crores of home buyers' money, my lords, only 10% is being executed by the government, the state, my lords. The accused builder is the top defaulter in the state of Karnataka, my lords. If they are not complying with the orders, then, and if the state is not pursuing them to implement these orders.
What is that order to be complied with?
My lords, I have purchased a flat, my lords, and they have not completed it. All the licenses are revoked, and I now go and ask for a refund because whatever I've paid according to the RERA Act, I am supposed to get back my money. And these execution orders are nothing but I am getting back what I have paid for my house. I don't want the house
You're
now.
not chosen to opt for the property. You
My lords,
want the-
property is not completed. The licenses are revoked. Everything is done and dusted. In 2021, I have got my execution orders.
Tomorrow,
Please, my lords.
tomorrow if your senior doesn't
Please,
give me,
madam.
Please.
My lords,
You are for madam.
my lords, I appear for the respondent in the contempt matters, my lord, the builder. I appear for the builder.
The
Please.
same part.
Same
Please,
party,
my
party
lord, the same.
My lords, meanwhile, let the state submit a compliance report. It's been due from past 1 year.
Tomorrow we are hearing appeal.
Please, my lords, but let them file a compliance report. Whatever work they have done, let them show it before this honorable court so that we'll be satisfied of what work they have done. We'll appreciate.
Lord, in 144.1, the state has filed a compliance.
Mr.
That is for accused number 1 and 2.
Right.
For 4 and 5, you'll have to file a affidavit.
Tomorrow we'll try to find out the
Please.
logical and.
Please, my lords, please.
Sir,
Please. I oblige, my lords. I'm at your lordship's hand.
when both the parties become unreasonable, it is difficult to decide.
Please,
In
my
fact,
lords.
there are multiple proceedings.
Please.
Tomorrow at 2:30.
Great.
Please. Lords, at 2:30. Please.
My lords, I had moved the memo for listing, my lords, and the liberty given by the Supreme Court. I had moved the memo for
45.
listing, my lords.
Is
The
the
transmission of
Transmission.
TV channel, that issue.
My lords,
I have not applied the mind. Just come back for a clarification.
I have not been provided any copy of the memo that they have moved, my lords.
I had only moved a memo for listing, nothing much, my lordship, annexing the orders of the Supreme Court.
Listing memo copy, listing
Well,
memo copy is not
listing
supplied to the
that's fine, because the audit sheet
Only
reads,
listing, nothing.
I mean, the cause list reads, there is a memo.
listing memo copy.
Who is the original petitioner?
The original
the
petitioners
original
are the respondents, my lords. They had withdrawn their.
You withdrew the petition.
My lords, it was a technical issue, my lords. My lordships had allowed her prayer. My lordships confirmed the writ petition order. So it was suggested by the appellants themselves as a matter of technicality, the matter is to be withdrawn before your lordships and then disposed of. After succeeding before the single judge and also before your lordships, if not for a technical procedural issue, we would have not withdrawn the same as such.
My lords, if I may be.
Upon succeeding before my lordships, it doesn't make
So this is some lack of clarity
My lords,
of our order in respect of continuance of interim order or what?
my lords, twofold issue, my lords.
May make this.
my lords, if I can make one submission, my lords. So with all due respect, the Union of India has absolutely no stand in this particular clarification because the Honorable Supreme Court in its order is very specific that if any modification or clarification is to be sought, it is to be sought by the original writ petitioners. And the right manner to go about it is to file an application, my lords, to seek that modification. Let them state whatever they have to state on affidavit. I will file detailed objections to that.
Who are you?
I am the appellant in the writ appeal as well as before the Honorable Apex Court, my lords. I am the specially petitioner before the Honorable Apex Court.
May I make
Power
this
Smart Media, my lords.
You are Power Smart.
Power Smart Media. My lords, and also my respectful submission, if my lords may kindly look at the first paragraph of the order of the Honorable Apex Court, it is very clear, my lords. It says prima facie on a plain reading of the operative part of the order.
Which order is perceived to be continued?
My lords, the interim order passed by the learned single judge. That is the issue, my lords. In fact, that list came to a complete closure as per their own submission.
So where is that interim order?
My lords, that interim order was part of the writ appeal paper book, my lords.
No, learned single judge interim order about which now there is a confusion whether continued or not. Which is that?
So in fact, my lord.
May I make-
My lords, if my lords have the,
I'd like
if
to
my lords
respond
have
to
the
what my
original.
learned friend said. Lord, Union of India is a party to the proceedings. Lord, he cannot say that.
But
I
the
have no
liberty
say.
is not granted to them, with all due respect, my lords.
In your lordship's order, please turn to para 5.5.
My lords, page 18 is the order of the learned single judge in the writ appeal, my
Will
lords.
hear you all.
In your lordship's order, which was challenged before the Honorable Supreme Court, para 5.5.
5.5.
Para 5.5. A temporary prohibition on the telecast in such circumstance could not be said to be violation per se of the fundamental right. The temporary phenomenon to prohibit cannot be equated with absolute restriction. The right to telecast is subject to regulatory measure. In the instant case to be stated at the cost of repetition, license of the appellant has already expired. Well, this was my submission. All these circumstances could be viewed as reasonable and good grounds not to permit the telecast in the interregnum pending decisions of the alleged violations. So therefore, my lord, your lordships, well, what happened was, your lordships then once again reiterated in 5.6 in the last 3 lines. In the next page, para 5.6, last 4 lines. It is in this light that the learned single judge passed the impugned order to stop the broadcast pending the testing of allegations against the broadcaster and the owners. Then, my lord, your lordships proceeded to summarize in para 7. In para 7, probably this should have been added. This was not added. That led to, that is now what begs for clarification.
My lords, in that light, my lords, also paragraph 9 would become extremely important. It is paragraph 9, my lords. Paragraph 9, if I may kindly read, my lords. In view of the arrangement and the order passed, learned advocates for the parties, in particular the respondent original petitioner, could not dispute the subject matter of the petitions, and the prayers in the petitions could have to be finally dealt with. Since the above directions are issued, learned advocate for the original petitioner therefore seeks the disposal of the main writ petitions by way of withdrawal. When the writ petition
My
itself
lordships may
stands
read
withdrawn, my
para 10
lords,
and also
my lords,
para
that's
11,
fair.
my lords.
I did not interrupt them when they were making the submission. When the writ petition itself stands withdrawn, my lords, the interim order could not have continued. In fact, it is in this slide, my lords have passed the operative portion, which is captured in paragraph 7, my lords, which very clearly lays down the time frame for them.
That is exactly what Union of India is saying. Interim order is not continued.
That's exactly what the Supreme Court also says. The interim order is not continued, my lords.
Then what clarification?
No, my submission is that by virtue of your lordship's order, it was clarified that since there was expiry of the license, the operator could not have continued the broadcast. That is what is found in para 5.5 and 5.6.
That is also you can read with your perception.
I'm sorry.
What is the clarification needed?
I have no clarification, my lord. It is for them to see.
You tell us.
My
We want to
Our say before the honorable.
declare, or you want us to declare that the interim continues, or what is the clarification?
We are telling, having regard to the body of my lordship's order, the interim order was continued at para 5.5, my lords. That was our say before the Supreme Court. One more say, what I would like to say, if
Who are you?
we are the original petitioners, my lords. Respondents hearing.
My lords, my respectful.
Your learned friend is not for original petition.
Is for the media.
I'm for the.
For
We are for the aggrieved petitioners.
broadcast.
He is the complainant.
No,
He
I am
is
the
I
complainant.
am the broadcaster, my lords.
Complainant.
They are the
But my
complainant.
complainant writ petitioner. He lodged a complaint with us, with the central
You
government.
are interested in continuance of the interim order or whether,
We are interested in the continuance of the interim order.
which interim order?
But the,
Single judge's
my
interim
lords,
order.
what has happened is,
So that order.
The interim order prohibited me to broadcast, my lords. They are interested in continuing that interim order. My lords, my lords, if I may kindly make one submission, my lords.
When this,
may I make the submission, my
when
lords?
the matter is coming?
In March, my lords. The matter is coming up in March. My lords, if I can make one submission, my lords. My lords, the Honorable Supreme Court, my lords, by its order dated 12/7/2024, has completely stayed the order of this Honorable Court dated 3/7/2024, my lords. Subsequently, my lords, the order dated 14/11/2024, that is before my lords came to be passed. My lords, if I may kindly read that order.
May I
My lords,
pass on the orders passed by
just-
the honorable Supreme Court?
My lords, if I may kindly read that order, my lords, it says, the opening paragraph, my lords, prima facie on a plain reading of the operative portion of the order, that is the order dated 3/11 of this court, my lords, we find that the order of the learned single judge was not continued.
Wait. The order of learned single is not continued means what? What is the effect of it?
My lords,
You are permitted to.
I'm permitted to broadcast. In fact,
So then you withdraw the petition.
I did not, I was not the petitioner, my lords. They were the petitioners. That is why they want to now resile from their withdrawal. They want to resile from their withdrawal because of the fact that the interim order did not continue. They want to contend, no, the interim order continued. They want to resile from their withdrawal, my lord. That is the crux of the matter.
May I answer this?
Their estopped from now resiling from their withdrawal, my lords, would be my respectful submission. And this amounts to literal review of the order, my lords, not a modification or a clarification. And that cannot be granted without a proper application at all.
But in any.
My
case-
lords,
In any case, Mr. Our order is stayed by the Supreme Court.
no,
Yes, my lords.
my
Precisely, my lords.
14
I'm in respectful agreement with that aspect, my lords. In fact, the second paragraph of the Honorable Apex Court order very clearly says this, my lords, that the stay is lifted or the stay dated 12/7/24 granted by the Supreme Court is modified only to the extent that clause 1 to 5 of paragraph 7 to adjudicate the show cause notice is lifted, my lords. And if the original petitioners are at liberty to seek clarification or modification, and that has to be sought through a proper application. Apart from that, rest of the portions of the judgment continue to be stayed by virtue of the order of the Honorable Supreme Court dated 12/7/24, my lords. They just want to resile from their withdrawal.
Can I answer this?
That is the entire motive.
The next two paragraphs would also be relevant.
My lords,
for
my
the
respectful
Honorable Supreme
submission
Court's
would be,
order.
let them be directed to file a proper application, my lords. Let them put it
Application
on
would be
affidavit,
interpretation
whatever they
of the
want to
Honorable
state,
Supreme Court's order, which we
so that
do not
I am
want to
also
do so
given
as
an opportunity to file my objections.
Supreme Court has given liberty.
liberty, my
My
lords.
lords, that liberty has to be exercised through a proper manner, my lords. They are asserting the fact that they have not withdrawn the writ petition. That assertion cannot be taken on their respectful statement as it is, my lords. Let them swear to that fact.
Can I read the subsequent paragraphs of the Honorable Supreme Court order, my
File
lords?
some memo or some clarificatory application. Something is filed.
Nothing is filed, my lords. Nothing is filed, nothing is
My
served
lords,
on me.
we had only moved this court for listing, my lords, because we didn't want to interpret the orders of the Honorable Supreme Court.
Form of application. So we know that what is the scope of your import of your contention, scope of.
We'll do so, my lords. If application is necessitated, my lordships might kindly have it in first week of January. We'll file the necessary applications as such.
Second week of January.
My lord, second week of January, my lords, because the Supreme Court also reopens during that time, my lord. The learned senior counsel appearing there would want to.
Your date. you-
Second week of January. my
Court
lords.
also opens in second week.
Any date in the second week of January would suit us, my lords. 2:30, my lords.
Either 16 or 20th.
16th or 20th, my lords.
16th, my lords.
Any day which is not a
16th.
Monday, my lords, because Monday would be a miscellaneous day there, my lords. That would be the issue.
So you are practicing there.
No, my lords, the learned senior appearing in the Supreme Court would want to appear here, my lords.
So 16.
16th, my lords.
Yes.
16, 2:30, my lords, subject to my lordship's discretion.
Bound to take. Court's decision.
My lords, they may be instructed to kindly make necessary application, my lords, because on that day also,
They are filing.
That's the submission of
their
myself before this
submission may
honorable.
kindly be recorded to that.
They are also update you that something in black and white should be there before us. So no outline you clear.
Very much, my lords. We'll file the necessary application as such. One request, my lords, the timeline fixed may be adhered by the union, my lords.
Some inaccuracy on the part of the author of the order. There is some inaccuracy, it appears. Because
My lord,
my
only
part.
in the summary, the essence of what is found in 5.5 was not carried forward to para 7. That's the only.
My lords, my respectful submission would be that summary did not carry forward because of their submission to withdraw the petition, my lords. When the writ petition stood withdrawn,
We will file the necessary
But couldn't-
application. Let them reply also, my lords.
Notwithstanding the withdrawal. we
No,
can
my
try-
lord, the logic is like this. Learned single judge prohibited. That order was challenged. Your lordships have not set aside that order,
my
but
lords,
rather upheld it. Having upheld, what happened? Did it just evaporate in thin air? No, it was absorbed into your lordship's final order. That would be the stand of the center. Your lordships have
sorry, my lords.
rejected their contention and upheld the order of the single judge. What happened to that upheld order? It cannot just disappear.
My
It
lords-
was subsumed.
My
It was
lords,
subsumed
the
in your lordship's final order.
contention of the learned senior counsel would hold valid if, my lords, the writ petitions were transferred here and disposed. That was not the case. In all their consciousness, they withdrew the writ petition because they said that main prayer had been achieved, which was the adjudication of their complaint.
Not
It is in
adjudication,
that
but-
regard, my lords, that the petition came to be withdrawn.
because
Today you are telecasting or not telecasting?
I am telecasting, my lords. I am telecasting. Now they want to preclude me from, they want to overcome the order of the Honorable
Your
Supreme Court.
telecasting is the necessary consequence of stay of our order.
Stay of this order, man. That is what they want to overcome now, my lords. They want to overcome the stay of the Honorable Supreme Court by trying
No,
to
no.
seek this.
Honorable Supreme Court has now
Granted us
already
liberty,
granted
my
your
lords.
Your lordships can now decide whether the
My
interim order
lords,
got
there
substituted.
again, my respectful submission would be liberty is granted to respondent number 2 and 3 who are the original petitioners. I fail to understand why the Union of India is so aggrieved by this.
It's the adjudicating authority. It is interested, my lords.
They are party and all parties are submitting.
My lords, if they were so, this one, my lords, we have produced a list of 40 channels which are operating similar to us. The only reason that we have been victimized is because we broke the sex scandal of a particular sitting MP. It is because of that they have tried to. I put it all in on affidavit before the Honorable
These are
Supreme
not
Court, my
relevant
lords.
for clarification. We apply our mind also.
One last issue, doctrine of merger would be applicable, my lords. I'll file my necessary IA. Let them also reply to my clarifications, my lords, so that the pleadings are complete on 16th.
We'll see on 16th.
Number 146. To Chandrasekhar GM. To Chandrasekhar GM.
What is it?
The Lordship had passed an order with regard to the transfer of salaries as per their representation. From yesterday, it's been posted today, my lord.
What to be earlier? Earlier number 143. 143. Keep this order. Learned advocate for the complainant has been consistently absent. Learned additional government advocates, Srimati Sweta Chinap has stated about the complaint, has made a statement that the complaint is, that the order is complied with. Send over to 16th. And January.
Much.
Number 147.
The last occasion, my
matter,
learned
right.
friend wanted to argue on maintainability of the contempt, if your lordships recall. This is the order which is confirmed by the Supreme Court. 1 year up, my lords, now. The order of the learned single judge, lordships would get, my lords, that page. It commences at page 20. Operative portion is at 28. Clause 5. This is the order, my lords. After filing contempt, they filed a SLP. SLP is dismissed. Then, my lords, they argued and moved the single judge again.
I thoroughly examined, my lords. I think I made a very, very incorrect submission.
on the maintainability, my lords, but the fact remains that the implementation of the order in all similar matters is before the JMFC court. Everywhere they go and give the surety and it is being implemented before the JMFC court, my lords. I apologize on the maintainability. It's my incorrect submission. I apologize.
The week prior to that, they had said there is a meeting and they'll release. Your lordships adjourned it like that.
Now what are you? You are complaining?
My lords, my only submission is the learned single judge's order, which is under contempt before my lords. And the page number 28, my lords, there is a direction for the chief conservator of forest to release certain amount of iron ore in crime number 17 of 2009 and 10, for which as learned senior counsel submitted, my lords, we preferred an SLP. In the SLP, my lords, the apex court observing that there is a protection given under the para 5 and 4 of the order, where you can take surety to the iron ore. Para 5, my lords, it says, the Assistant Conservator of Forest, Ankola, Uttar Kannada district shall determine the actual quantity of iron ore available, which is stacked by the petitioners, and also determine the value of the iron ore. Upon determination of the RFO, shall release the said quantity of iron ore to the petitioner, and which one surety each, and on executing the indemnity of the bond by the petitioners for the value determined. This is the direction. Based on this para 5, my lords, in the SLP, the apex court, my lord, says as para 5 is available, they think that it is not a matter for interference. Then, my lords, they file the contempt is filed, and this iron ore is, my lords, worth 7 crores. And the surety now which is being offered is 10 lakhs. So we again go back to the learned single judge seeking clarification as to what should be the surety for the iron ore which should be released. My lords, the learned single judge, when we move an application for being spoken to, learned single judge, my lords, clarifies. And what happens is in that order, my lords, may I just pass it on.
It's there in the file, my lords.
I'll just give it for. This is a subsequent order after that order, my lords.
26 June.
Put it there.
There on record.
I'm sorry. My lords, in this order, my lords, learned single judge, if my lord sees the order, I'll just read it. The special investigation, only it's a single paragraph, my lords. The special investigation team, after investigation in crime number 2 of 14, submitted B report insofar as it relates to petitioner in criminal petition so and so. Insofar as it relates to criminal petition so and so, no case was registered for alleged unauthorized stacking of iron ore in the port. Therefore, the request to the state government to include one surety for the like sum amount is rejected. So, my lords, now the Honorable Court has rejected our prayer for like sum amount, my lords. On this order, my lords, we are preferring an SLP, my lords. It's a government order. The only request is it may be taken up after 2 weeks, my lords. We will can report to court what happens in the SLP. Because we are going to release I don't know what, 7 crores for 10 lakhs, my lords. Then if we win the case in crime number 17 is still pending. This crime number 2, my lords, was about theft of the iron ore, which was already seized, the second crime. The first crime under which the forest seizes this iron ore, my lords, it's still pending. And tomorrow, my lords, if it is treated as illegal, it will be difficult for us to. That's the only, we are going to prefer an SLP is my submission before my lords.
So originally, we are concerned with this criminal petition number 7827 or 758?
My lords, presently 758.
7582, my lords.
7.
That's 7.
So because the apex court said, because the protection under 4 and 5 of the order, which says that value determined. Now again, my lords, when we seek for clarification, no like sum is what is learned single judge's order. So my lords, we are now preferring an SLP on the subsequent order is my respectful submission. Hence, I request 2 weeks time, my lords.
May I just submit this? Very unfortunate. The then government advocate argued the same point before my lords. On the surety point, we pointed out indemnity to the value and my lord surety. After your lordships heard, they moved the matter. Now that order is passed on 26 June 2024. This contempt, I don't know how many times it's been coming here. This order is of June 24. When they moved the matter seeking a clarification before the single judge, that was what was said. When it comes here 3 times, they say we are taking a decision, we are releasing. Today to bring about a June 24 order and saying that I'm going to challenge this order. Lords, for 1 year, if somebody has to play around like this, my lords, it's very unfortunate. That's precisely, that issue should have been, and there is no modification. Learned single judge never modified his order. Please see the order. They sought some modification after the SLP was dismissed. All these things were argued by when they filed a memo on 18/6/24 in this contempt matter.
Even this can be insisted upon. Whether the states succeed, this condition can be insisted upon. And then the rules it will be subject to SLB. Begin this. That is only condition.
And that memo was moved by them to include that clause, condition, when the contempt was pending.
This contempt petition relates to non-compliance of directions issued by a single judge in common order dated 25th September 2023. Insofar as the said order relates to criminal petition number 7582 of 2018. It is a petition whereby order dated wherein, it is a petition wherein order dated 3/9/18 asked for the learned sessions judge and special judge CBI was challenged whereby the said court had rejected the application of petitioners for release of iron ore filed under section 451 and section 467 of the Code of Civil Procedure. Thereof, while setting aside the order dated 3/9/18 passed by the court below, learned single judge directed the respondent conservator of forest, Umkola, to release the iron ore seized from the petitioners. One of the conditions for release of the goods was that the assistant conservator of forest shall determine the actual quantity of iron ore available, which was tagged as TSEKD by the petitioners, shall also determine the value and upon value thereof, and upon determination, the range forest officer released the said amount, said quantity of iron with one surety each to be executed, to be given by the petitioners along with execution of the indemnity bond for the value determined. So what is the dispute now?
My lords,
Say,
the
for the
dispute,
value determined.
but now by way of the new order, my lords, where on order dated 26 June 2024 in the same writ petition, the court says one surety for like sum amount is rejected.
It was never so.
Indemnity,
If my lord sees the SLP order, my lords,
absolutely. It is there on record, my lords, the SLP order.
my lords, when we preferred an SLP, my lords, the apex court observing para 5, my lords, the apex court, my lords, the second page, I'm sorry, I marked it, my lords. In view of the conditions imposed in clause 5 of the operative part of the impugned order, the apex court, my lords, dismisses our SLP.
Then where what remains?
Now,
This
now
same
again, when
point-
we went for clarification before the learned single judge, what is the amount to be determined, my lords?
Oh.
One surety for like sum is rejected. So
just
now
submit
the
this.
value, my lords. which
Every
has-
time the others,
The aforesaid order was carried in appeal by way of special leave petition in the criminal diary number 18017/24 before the Honorable Supreme Court, which was rejected by order dated 17/5/24. Paragraph. The order of the apex court reads as under, and you quote this. Dialogue condoन से लेके यहाँ तक पूरा. Thus, the special leave petition was not entertained, especially in view of conditions imposed in clause V
5, my lords.
of the
Clause
order,
5, Roman
which
5.
which required the assistant conservator of forest to determine the actual quantity, determine the value, and thereafter release the quantity of iron by iron requiring the petitioner to furnish one surety, and on executing the bond, indemnity bond of the value determined. Full stop. It could be successfully submitted by learned senior advocate Mr. Anindra that once the order is confirmed by the Supreme Court, no option is left with the respondent authorities except to implement the order in its letter and spirit. learned additional Advocate General is Pratima Honnapura. However, stated, submit that on part of the respondents, there was some confusion
Memo
About-
for being spoken to was filed, my lords.
about the group of words, one surety. According to them, the one surety was to be equivalent of the amount, like
Which was
going to
argued
be
even
like some,
prior to that.
full stop. With such prayer, with such prayer and seeking such clarification, comma, the memo for being spoken to was moved for learn a single judge in respect to the aforesaid order dated so and so so and full stop. Learn a single judge passed order on 26th June 24, rejecting the prayer. The order reads as in this order to report. In other words, the order dated, where is that order, original order? Order dated 25th September 23 stands reaffirm and reconfirm in the same language and its import as it is passed, comma, the memo for being spoken to having been rejected, full stop. Learned additional Advocate General, Mr. Pratima Honnapura, however, submitted that the authorities have decided to appeal the Supreme Court against the aforementioned order dated 26th. Against said order, 26th.
26, 6/24.
26 June 24. When the query was put to learned additional Advocate General about the filing of the, about the moving of the Honorable Supreme Court by filing the appeal of special petition, comma, learned additional Advocate General was at her receiving end to fairly state that so far no such petition application is filed before the apex court. Full stop. In the above circumstances, when at this stage no option is left for the authorities to comply with the order, this court grants 3 weeks time to comply with the direction. Full stop. With such time granted, with such order of granting time for 3 weeks, so with such observation of granting time for 3 weeks to comply with the direction of a single judge in order dated, original order dated so and so, comma,
25th September 20.
25th September 23. Read with order dated 26 June 24. Closed. The contempt proceedings are closed with liberty to revive.
Lords, Lordship may call it, because again I'll have to file an application. This will not for one, my
contempt-
past experience says so.
Contempt proceedings are adjourned to
Please, my lord.
28th of January.
Please.
Much obliged.
List number 2, seal number 1. Mr. Gangi Reddy.
Compensation. Okay.
The learned single judge, my lord. Last occasion I already submitted. The learned single judge has disposed of the requisition filed by the fifth respondent, questioning the order in appeal number 129 of 2010-11. And actually there are two appeals pending before the second respondent. A common order was passed on 7/1/2012.
Second. That he's saying that. Common order, but.
The common order
particular
was
appeal.
passed. But my the common order was passed.
Yesterday was there, same man. It was there yesterday. This was there yesterday.
It was not there
Day
yesterday.
before.
It was not there yesterday.
Yes.
A common order was passed, my lord, wherein the order of the deputy commissioner was set aside, but the fifth respondent has not questioned the order in my appeal. And the learned single judge passed the entire order of the second respondent. But here, before the learned single judge, my lord, the fifth respondent has not sought for the quashing of the order passed in my appeal, that is 131 of 2010-11. But my submission is, once the party not seeks any relief in the writ petition, the learned single judge has granted a relief to him. It is not permissible. That is a supporting judgments of Supreme Court also on that line. I have submitted one judgment day before last occasion, my lord. And there are other judgments also regarding delay is concerned, my lord.
coordinate bench of this honorable court has taken a view. Once the purchaser has not taken any plea before the assistant commissioner regarding the delay, and they could not have taken the same plea before the High Court. But that is a violation of natural justice, because I have not given any opportunity to meet the arguments of the other side. So that is my submission. My lord, the coordinate benches of this honorable court has, two coordinate benches of this honorable court has passed an order in my favor. The lordship may kindly see, I have given a citations, my lord. Page 24, my lord, my 24, starts from 24, and a conclusion para.
Page 24.
The page 20, para 21. At page 40, ink page 40, the judgment. Ink page 40.
40.
Para 21. Similarly, in a situation where a plea of limitation was not raised at the earliest instance, an application seeking to raise the question of limitation was permitted to be made even at the appellate stage or before the apex court. In a special application, a reference may be made to larger bench editions in this case in management of the state of Bank of so and so, the town municipal council and so and so. In that context, in the case of town municipal council again so and so, seeking to raise the plea of limitation was served on the respondent well in time, so that by the time the appeals came to be hearing, they knew this point was sought to be raised by the appellant. The lordships held that a question of limitation raised a plea of want of jurisdiction, and in these cases, this question could not be decided on the basis of facts on the record, being a pure question of law. Then, while considering the word sufficient cause, so and so, Lord, the para 23, time and again the Supreme Court has held that there cannot be a straitjacket formula to decide as to what is the reasonable period for filing application or a writ petition, where there is a prescription of limitation. What is the reasonable depends upon the facts and circumstances of the case and statutory provisions governing the particular case. To give an illustration, if a person is granted land in the year 1975 and violation of the terms of the grant any land in the year 1980 and dies immediately thereafter, leaving behind a minor son as his sole legal heir, and the son makes an application under Section 5 of the Limitation Act in the year 2000, a few years after the attaining majority. The question that begs consideration is whether delay of 20 years in filing the application could be rejected on the ground of unreasonable delay or without sufficient cause. Obviously, the answer would be that sufficient cause is shown. There are any number of precedents where delay of more than 20 years have been condoned in matters relating to payment of compensation under Land Acquisition Act and the like. As noted earlier, there is nothing on record suggest whether the purchaser raising objections or plea regarding delay and latches before the assistant commissioner. On the face of the record, it is relevant that grantee was not called upon to explain the delay.
What do you?
Let's appear for the respondent number 5. There is a delay of 33 years. The land has been granted to the original grantee on 28/6/1954. We have purchased the property on 3/12/1969. 2003-2004, first time the legal heirs of the grantee have initiated the proceedings for restoration of the land under the provisions of the
They are
Act.
seeking compensation towards what?
From
Compensation. It is an acquired.
It's recently land has been acquired by the GoEDB. All the authorities have held that there are
You have purchased when?
3/12/1969.
Before acquisition.
No, before recently land has been acquired. 2006 subsequent to 2006-7 onwards. We have purchased the property on 3/12/1969. There is a delay of 33 years. First time the legal heirs of the grantee have
Reserving for all. Reserved. Heard, learn and evidence, all evidence, then usual order. Reserved for judgment.
Still number 2. Mr. Monish Kumar KB. Still number 2.
Learned advocate, but the appellant is again absent. Send all to 18th. Tomorrow.
Still number 3. Mr. Murthy K.
Same order.
Still number 4. Mr. Karthik C. Still number 4.
Upping for respondent for you. Respondent, same order, tomorrow.
Still number 5. Mr. V. Anand.
Same order.
Still number 6. Mr. P. N. Harish.
That the grantees appeal, my lord, the writ petitioners came to be allowed on the ground of delay and latches. My lord, my responsible submission is the PTCL Act came into force on 1/1/1979. The grantees made an application for restoration of the same immediately thereafter, that is on 13/3/1979. So the learned single judge, my lord, taking the date of sale lead from the year 1965, has allowed the writ petition and quashed the order of the Deputy Commissioner and Assistant Commissioner, who had passed an order for restoration and resumption of land in my favor. Well, my responsibility, the cause of action to claim for restoration and resumption, you would only come after 1/1/1979. So it is on 13/3/1979 itself, the grantees made an application for restoration. So it is in time. Millard, the learned judge Millard, the learned single judge Millard, kindly see page number Millard. Page number 25, Millard, para number 5 of the learned single judge order.
Now law is settled.
Pardon?
What is the delay?
Millard, delay, learned single judge says 1965 is the first sale date. 1965 is the first sale date. The delay is taken from that date. My responsible submission is the cause of action for the grantees to file application for restoration would come into picture only on 1/1/1979. Before that, there was no.
What is it, 1/1/96?
Millard, that is on that day, the act, PDCL Act came into force.
So then what, even then there is a delay?
There is no delay, Millard. 3 months only. Within 3 months, the application is filed. Kindly see, the application is filed on 13/3/1979. 2 months. Millard, that is available at the records.
Who is?
The notice is yet to be ordered. Notice is yet to be ordered.
Not, should notice.
Notice not ordered.
Notice returnable.
Obliged.
13th February.
Please. So far as office objections are concerned, I have made a note, Millard. I have completed it long back. Please.
Number 7. Mr. Parashuram A.
Beg to appear on behalf of the counsel for appellant, my lord. The counsel has some inconvenience, has requested me to seek a date after vacation, my lord. My lords kindly permit.
Line.
There are some office objections as well that
Serial number 7.
A date be fixed, my lord.
Whichever date you do.
Authorization or date के लिए आप-
That's all.
Serial number 141.
And I'll conclude today. Yesterday, I stopped, my lord, at the notice for arbitration that when I issued, the reply to the notice for arbitration had not raised any of these contentions which are now sought to be urged before this honorable court. Only 2 objections were raised at the time of the notice for arbitration and before the Section 11 court, which were the initial objections. That is, invocation of arbitration is premature. I should have resorted to conciliation first, which the Section 11 court said is a directory requirement. It is not a mandatory requirement. And secondly, contending that the amount of 23 crores is not payable for whatever reasons, because of fraud, etc. That fraud has vitiated the claim. Fraud is not arbitrable. These were the 2 contentions raised. Well, in volume 1, page 323, their objections are there. I have gone through their objections also in detail. These 2 contentions, that payment of penalty was conditional and therefore the amount of 23 crores need not be released so long as penalty is imposed, is not a plea raised. And the fact that the settlement agreement has been given the go by because the amount claimed is 37 crores, which is the arithmetically the total amount of the claim prior to the settlement, which are the 2 contentions now raised. In the objection statement also, those pleas are not there. At page 323 in their objection statement, these pleas do not find place. Stray sentences here and there are there. I do not say that absolutely nothing is said. Some reference to penalty here and there is there. But the plea in so many words that the settlement agreement has been given the go by because of the amount not raised. The fact that penalty has been imposed and therefore the 23 crores is not payable, not raised. Now we come to the arbitral awards. Page 91 of volume 1, my lord, is the preliminary award where those 2 original contentions which they consistently raised in reply to the notice, thereafter before the Section 11 court and also before the arbitral tribunal under Section 16 were considered. Preliminary award at page 91. The learned arbitrator deals with those 2 submissions. One, where the invocation of arbitration is premature. The learned arbitrator says that is a directory requirement, that is not a mandatory requirement, relying on certain decisions, and that has now become final. As far as the allegation pertaining to fraud is concerned, the learned arbitrator says fraud is not raised before me in a statement of claim. It is contended or it is alluded to in the complaint before the police. That is a different proceeding. There it can go on. That does not vitiate the claim before me. In any event, no complex evidence is required. Therefore, Section 16 is rejected. Those 2 objections which they consistently raised have been rejected by the Honorable Tribunal. Then, my lord, we now come to, if I may persuade my lord to just look at page 105 in volume 1, what were the issues before the learned arbitral tribunal? That these pleas do not find place. Page 105 are the issues framed by the learned arbitrator. The pleas are fairly straightforward.
whether the claimant proves that the respondent is liable to repay a sum of rupees 4 crores with interest, because that was the first requirement. Page 105, my lord, in volume 1. That is the award, internal page 9. Correct. Issue number 1, whether the claimant proves that the respondent is liable to repay a sum of rupees 4 crores with interest. Issue number 2, whether the claimant proves that the respondent is liable to pay 23 crores with interest. 3, whether the claimant proves that the respondent is liable to pay a sum of rupees 14 crores, etc. towards damages. Whether the respondent proves that it has only received 17 crores 24 lakhs from NILIT after the signing of the settlement agreement. Whether the respondent proves that it is entitled to legitimately retain all the amounts received from NILIT. Let I pause here for a moment. If these were the pleas that they intended to urge before the tribunal, nothing prevented the respondent therein, the appellant herein, from requesting the tribunal to frame the issues on those pleas. Those pleas were not urged. They were not urged before the tribunal, as is evident from the issues. Well, and I have had the benefit of personally arguing before the learned arbitrator also. These were not their pleas. This is ingenuity of lawyers. They are aided by very excellent lawyers. The lawyers have now come up with this argument. But these are not the pleas. And when these are not the pleas, the learned arbitrator has gone by whatever the contentions raised. These are the only contentions. If it is their contention that the learned arbitrator has ignored, it will have ignored only if you urged them. What did you do when the issues were framed? Nothing prevented you from seeking recasting of these issues. Now, looking into these issues, look at what the learned arbitrator has done. Well, issue number 1 is no longer an issue because they are not pressing on the issue of the 4 crores. Well, page 118, para 44. Issues number 2 and 4 were taken up. The claimant said, look, settlement agreement says 23 crores. The respondent said, I have received only 17 crores. Issue number 2, claimant said, I'm entitled to 23 crores as per the settlement agreement. The respondent, issue number 4, said, I have received only 17.53 crores. How did the learned arbitrator deal with it? Para 44. I propose to take issue number 4 first because the finding on it is required for answering issue number 2. That the respondent has received 17.24 crores from NILIT after signing of the settlement agreement is not in dispute at all. The respondent has stated in para 15 of the statement of objections that it has received the payment of 17.24 crores from NILIT on 9/3/2018. This position is reiterated in para 20 of the affidavit for RW1 filed by way of examination in chief. This position is not disputed by the claimant side while cross-examining RW1. I have no hesitation in answering issue number 4 in the affirmative by holding that the respondent proves that it has received only 17.24 crores after the signing of the settlement agreement. Now to issue number 2, page 119. The reference has to be made to clause 1 of the settlement agreement, which reads as follows. SAS agrees to pay 23 crores as full and final settlement, which will include receivables from projects. This money will be called as final settlement money. SOS agrees to pay the amount of 23 crores as mentioned below, as and when the same is received from NILIT. Perusal of the aforesaid extracted clause reveals that the respondent is obliged to pay 23 crores towards the full and final settlement of the claims. Said clause further states that the amount has to be paid as and when it is received from NILIT. This clause has to be seen in conjunction with clause 3 of exhibit P1. At the risk of repetition, it is extracted as below. Any payment received in the escrow account shall first be set off in favor of emphasis for amount of 4 crores and the balance payments received shall be allocated between emphasis and SOS at the ratio of 61% and 39% respectively until emphasis has been paid in all, a total sum of 23 crores as mentioned above. What the learned arbitrator says, looks at is the first few words of clause 3. Any payment received from NILIT will be deposited in escrow and distributed 61 to 39. Perusal of the extracted clause makes it clear that from and out of the amounts received by the respondent from the NILIT, an amount of 4 crores has to be first given to the claimant. In the remaining or balance amounts, the claimant is entitled to 61% and the respondent is entitled to 39% until such time that the claimant has been paid in all a sum of 23 crores. Set of sum of 23 crores is to be paid by the respondent to the claimant as and when it is received from NILIT. Admittedly, 4 crores has been paid, my lord. Para 49 is on 4 crores. The balance amount, my lord, fourth or fifth line in para 49, balance amount of 28 lakhs released by NILIT into joint escrow account is available for being apportioned in the ratio of 61% and 39%. Same is in addition to 17.24%, which amount is directly released by NILIT to respondent. Totally, a sum of 17 crores 53 lakhs is thus available for apportionment. 61% of the said amount comes to 10 crores 69 lakhs 59,000. My lord had asked on yesterday at page in the final award, how did this amount of 10 crores 59 come about? What the learned arbitrator has seen is from NILIT, after that 4 crores due to me is taken away, from NILIT, the amount available for distribution is 17.53 crores. 61% of 17.53 crores is 10 crores 69 lakhs 59,630. 39% is 6 crores 83 lakhs 84,200. These are the amounts and this is the manner in which the learned arbitrator has apportioned. The claimant's argument that it is entitled to get 23 crores in addition to 4 crores, irrespective of whatever the amount is received from NILIT, is negative. Issue number 2 is answered partly in favor of the claimant and partly in favor of the respondent by entitling the claimant to receive a sum of rupees 10 crores in addition to 4 crores and the respondent to receive 6 crores. The interest aspects will be discussed in the later part of the award. Needless to state that if the respondent recovers further amounts from the NILIT, same are also to be apportioned as per the settlement agreement. But again, I'll pause here for a moment. This is the interpretation given by the learned arbitrator to the settlement agreement. Now, what the appellant needs to do to succeed before this honorable court is to say and persuade this honorable court that this interpretation is untenable, completely impossible in law, that such a interpretation ought to shock the conscience of the court. That is not what emerges. The learned arbitrator has treated the parties fairly in spite of the conduct of the respondent in diverting the funds and closing and avoiding the remittance into the escrow account. The learned arbitrator has been fair enough to grant them their 39%. He does not say because of your conduct you are penalized, which is what I sought to urge. I sought to persuade the tribunal that they are disentitled, that they are not entitled to the 39%. I should get the full amount because they have promised me 23. The arbitrator says, no, 23 is all right, but you will get 61%, he will get 39%. Then, my lord, issue number 3 he comes to as far as my damages is concerned. He says, look, you have not led any evidence. You have not, he in fact looks into my examination during the trial also. Because there is no evidence that you have suffered any loss on that account. Therefore, your claim for damages is also negative. So I do not get my full 23 crores. I do not get my full damages. All that the learned arbitrator says is, you agreed, both of you, 61%, 39%. That is all that I'm going to give. 61%, 39%. These pleas were neither urged, for the sake of repetition, my lord. These pleas were not urged. They do not find place in the issues. Somewhere in the objections in the pleadings, there may be references here and there, but in so many words, as propositions, never urged. This, my lord, is taken in by way of that application under section 34 before the learned district court. That judgment, my lord, which is the impugned judgment before this honorable court, is to be seen at page 49 of the first volume. Page 49. At page 67, the discussion commences. Again, before the section 34 court, several grounds were urged. If I recollect correctly, more than 30 grounds were urged before the section 34 court. The section 34 court looks at from page 67, my lord. The reasons are set out. Paras 15 to 20, the learned district court sets out the scope, saying, look, under section 34, this is what I'm entitled to do. This is what I can do from para 15 to 20. Then the issue of jurisdiction, my lord. Again, what was argued before the section 34 court I repeat once again, were those only two objections. One, that it is tainted by fraud, and two, the invocation of arbitration is premature. Those are the only two arguments raised. That also is dealt with by the learned arbitrate, by the learned section 34 code. Look at para 21, page 70. Para 21, page 70. The applicant challenged this award on the ground that the arbitral tribunal has no jurisdiction to adjudicate the matter. The terms of submissions to arbitration, as can be clearly called out from clause 5, has not been addressed at all by the learned arbitrator while passing impugned award. The notice of reference at exhibit P8 dated so and so prima facie reveals that no negotiation in terms of clause of 5 in terms of, have been held between the parties. Again, premature invocation. That is what is urged before the section 34 court also. Section 34 court considers that, and at page 28, para 28, renders a finding saying that the learned arbitrator has dealt with it appropriately. Para 28, page 28. You have not challenged the section 11 order also. Therefore, that is not a ground for intervention with the award, after considering the reasons. Then, my lord, the second objection, which they raised consistently in reply to my notice for arbitration before the section 11 court, before the learned arbitrator, fraud. That was a contention raised. Para 29, the section 34 court looks into that also. Para 29, page 28. Petitioner has taken another ground for challenging this award, that the arbitral award dated 26/11/2019 is liable to be set aside as alleged disputes do not fall under the category of arbitrable dispute that can be adjudicated by a private forum. My lord, I am at page 76 of the paper book. Page 76, para 29. Where this issue that my claim is in the nature of fraud, and therefore fraud is not arbitrable. Ink page 76 in volume 1. Para 29, my lord. Para 28 is a finding on the first objection. Para 29, the section 34 court takes note of the second objection. Petitioner has taken another ground for challenging this award, that the arbitral award dated 26/11/2019 is liable to be set aside as alleged dispute does not fall under the category of arbitrable dispute that can be adjudicated by a private forum, and hence the arbitral tribunal has no jurisdiction to adjudicate the same. Now, 29 to 35, the facts and the law are discussed by the section 34 court. And at para 34, at ink page 83, he finds that the learned arbitrator has dealt with it correctly, agrees with the contentions of the learned arbitrator. Para 34 at page 83. The learned arbitrator held in orders on preliminary objections, that is, my lord, the section 16 award, that the point that arises for my consideration is whether the allegations of fraud are so very serious that the disputes raised in these proceedings are to be held as non-arbitrable. In Ayasamis, the Honorable Supreme Court has held that mere allegations of fraud simpliciter may not be a ground to nullify the effect of arbitration agreement between the parties. In Swiss Timing Limited case, the Honorable Supreme Court has expressed the considered view that there is no inherent risk of prejudice to any of the parties in permitting arbitration to proceed simultaneously to the criminal proceedings. Para number 24 of the said decision reads as under. He extracts the finding of the learned arbitrator. And then at para 35, The reliefs sought in the claim petition can be examined independently of the allegations made in the criminal complaint. Ordinarily, every civil or commercial dispute, whether based on contract or otherwise, which is capable of being decided by civil court, is in principle capable of being adjudicated upon and resolved by arbitration, subject to the dispute being governed by the arbitration agreement, unless the jurisdiction of the arbitral tribunal is excluded, either expressly or by necessary implication. Arbitration is an alternative to the civil proceedings. This is the finding by the district court, agrees with the finding of the arbitral tribunal. Then, my lord, they raised one more ground before the section 34 court. That is that, all right, all this is okay. I also have filed a civil suit. They have filed a civil suit against the directors for damages, contending that so many proceedings have been raised, etc. That the section 34 court deals with, my lord, at para 37. The petitioner has taken another ground to challenge the challenge of the award, that the learned arbitrator failed to consider that Exhibit P1 was not a document that created a liability, and alleged dues were not payable by the applicant herein to the respondent without any independent evidence being adduced of acknowledgement of any debt or liability. Learned arbitrator further adds that a commercial suit of so and so is pending between the parties, wherein the respondent has claimed 50 crores on the claimant while passing the impugned award. Hence, the award is liable to be set aside. Further, the learned arbitrator failed to consider the fact that the claimant on one hand contended the settlement agreement is enforceable, on the other hand contended settlement agreement was the result of inducement. Hence, claimant is entitled for payment of entire amount. Hence, learned arbitrator erred in passing the award impugned without holding that the claimant is blowing hot and cold. Learned counsel for the petitioner.
No finding. Contingents are urged, noticed.
No, this was not even urged before the learned arbitrator. That's what I began with saying. Learned counsel for the petitioner vehemently argued that it is a matter of record that as per Exhibit P1 it should be, the sharing of 61% and 39% and also the payment of 4 crores was subject to the estimated receivable amount of 36 crores from NILET. Even as per the award, the total sum received from NILET was less than 22 crores as opposed to the discussions held preceding the settlement agreement, which is evidence. For the learned arbitrator to exercise jurisdiction to distribute the same in the first place, total amount ought to have been remitted into the escrow account by NILET. The settlement agreement is not an acknowledgement of debt, but on the other hand, was just an arrangement to facilitate distribution only, subject to realization of entire receivables from NILET. In that view of the same, the learned arbitrator had no jurisdiction to decide on the allocation of funds, and hence the award is liable to be set aside. My lord, here is a party who enters into a settlement agreement, agrees that the earlier claim was a larger amount, promises to pay me 23 crores, and then has the gall to stand before a court of law and argue it is not an acknowledgement of liability. And my lord, the section 34 court is required to even go into that argument, because in our courts, in our jurisprudence, my lord, every party has a right to be heard on every ground. And that is why, my lord, the Supreme Court has been saying from 2019 to 24, where the shift in the approach has taken place. No, we do not need to be so tolerant anymore. The emphasis is now on enforcement of contracts. That's why, my lord, in fact, even in 2018, the Specific Relief Act also was amended. The emphasis is to abide by the contract. You cannot then be allowed to wriggle out of contracts by coming up with such specious pleas. And that also is dealt with by the Section 34 court. This being the position, my lord, to now say that this has been ignored, that has been ignored, primarily, my lord, the mandate of the Section 34 court, as well as this honorable court, as settled by the Supreme Court now, is to uphold the award. The sanctity of the award has to be maintained. If we now, in this court, look back at the learned arbitrator's award, there is no flaw. But some emphasis was laid, volume 3. Some emphasis was laid that evidence was there and it was ignored by the learned arbitrator. And reliance was placed on Exhibit R73 in volume 3. Volume 3. Look, this is last of my submissions, my lord. It's at page 903. Page 903. Yeah. 72 and 73. Page 903, my lord. I will need only another 5-10 minutes. this was pressed into service to urge the proposition that the learned arbitral tribunal has ignored the fact that penalties were imposed and penalties were required to be shared. What was pointed out was at Exhibit R72, some element of penalties were imposed because, my lord, if the horizontal table at page 904 is seen, 904, the horizontal table, there in March 2018, it would appear that NILET was saying that nothing is payable. In fact, there is a recovery of 1,11,76,865. That means the respondent had to pay back. It has received excess amount, penalties are imposed, and now the respondent has to pay back, which is what NILET had proposed initially in March 2018. My lords can see that it is negative 1,11 lakhs. If matters had rested here, which means no amount is liable to be received from NILET, we have to pay only. Then too, the settlement agreement said, if you have to pay back 61%, I will pay, 39% he will pay. That is the way the settlement agreement clause 2. Clause 1 said, if you receive 61%, 39%, if you have to pay 61%, 39%. If matters had rested here, I would have had to pay 61% of 1,11,00,000. He would have had to pay 39% of 1,11,000 is how the clause 2 of settlement agreement is read. What eventually transpired, my lord, is the next page, page 905. 13th April, and again, this is not the final award by NILET, it is only correspondence. It is only halfway. But what would appear here is at page 906. Some penalty appears to have been imposed because this, my lord, is an incomplete correspondence. We would not know the final picture. At page 905, 13th April 2018, page 906, the horizontal table, my lord. First, second, third, fourth. My lord, the fourth last amount here, withheld amount is there on top. Fourth last. Withheld amount. Withheld amount appears to be 1,12 lakhs. Yes.
So what you are demonstrating?
Well, in page 906, the fourth.
904.
906.
Anyway, I got it.
Yes, my lord. There, withheld amount 1,12 lakhs. Eventually, amount paid 21 crores. 21 crores is what has been received after that amount has been adjusted. So, page 906.
That page is not there.
Page 906 is not there, man?
That 906 is, page is not there. You give page tomorrow.
Very well, madam. Tomorrow, I'll take only 5 minutes and then my learned friend can continue. I just point this out and continue.
Well, my learned friend may finish tomorrow, madam. I have some difficulty, but I don't want it to be adjourned, madam. Kindly permit my learned.
And you will finish when?
Lord, I have an arbitration, Lord, it will go on for the whole week.
No, no, you will finish when? Day after.
Which one, my lord, the arbitration? No, my lord, it will go on the whole week, my lord. I have an arbitration, it will go on the whole week. So, but I don't want to interrupt the hearing, my lord, that's not fair. So, my lord, reply, my lord.
Your colleague will.
He will.
Not.
He will.
Very well.
I beg to be excused, my lord, please.
I will finish in 5 minutes tomorrow. Only this
My lord,
last
but
document I'll show.
He will go on.
Tomorrow.
2:30, man?
You completed the earliest and then we'll.
5 minutes. I have nothing more. Grateful, man.
With your lordship's kind leave. With your lordship's kind leave.
That's serial number 63, that high security number plate matter. The lordship may kindly fix a date after vacation.
Give some.
Interim
your
order may be extended.
Serial number
My lord,
28,
interim order may be extended.
28 and 29.
Interim order may be extended.
Serial number 28 and 29, my lords. It's a commercial appeal. My IA for stay is pending consideration, my lord. Execution is filed. It's listed on the 3rd of January. May I request for tomorrow or day after if it's not inconvenient to my lords?
Not possible.
Serial number 135.
Immediately after.
With your lordship,
Serial number
date may be fixed in the month of.
It will be given.
My lords, this is pertaining to the EWS matter.
Serial number 135, my lord. Land acquired by the KDB. Now, acquisition authority is not-
No, all after vacation. Yes.
This is-
Serial number 33.
What? Why party?
This is pertaining to the EWS matter, my lord. It was listed yesterday and the senior counsel was here to argue it in length. The economically weaker section land was being mortgaged by BBMP. And the connected matter was
What
directed,
do you want, madam?
our connected matter to be tagged along so that it's listed tomorrow, my lordship.
Tomorrow not. Go after it.
It is listed already, your lordship. It's just that the connected matter needs to be tagged along.
One.
One. Oh. Yes. 130.
130. Contempt डाल के है
After holidays.
नहीं वो लायर अभी नीचे गए तो बोलते
Yes.
45, serial number 45 and 47, lot, today's list.
45 and
45 and 47, please. In both the matters, I'm seeking mandamus to consider my representation, lot. Since mining lease has been executed by the state government, all clearances are done. They are not, the forest department is not executing the agreement to conduct mining operations. This has been delayed for a long time.
notice is it
Yes, Mala.
after vacation. Immediately.
Serial number 96 Malord.
Serial number
If I may
40.
please your
First-
lordship.
Serial
First
number
read.
96 Malord.
Like
Serial number.
15, 15.
Bottom.
If I may please your lordship.
Serial number 39, I am for the petitioner, my lord. My lord, state has to file an objection, they have not taken, this is a PIL matter, my lord. Kindly, my lord, have a date, my lord, after.
Date all, in all matters they will be given. In the second week of February onwards.
Serial number 44.
Number 32, my lord.
96 Malord. We have to tomorrow Malord because the occupier shall be passing an order to directing the accused to pay the maintenance Malord on or before 28th of November. For which Malord he also filed affidavit undertaking to pay the amount on or before 20th. Still they have not paid Malord, so the charge has to be paid. Kindly accept tomorrow Malord.
We are not getting what you are saying.
My lord, serial number 44, my lord.
14%.